perfectly proper. In terms of the amount of time that the evidence would take, I think the videos might add up to about 3 minutes. There's 4 videos, but they're short. And the evidence on it would be maybe a further 5-7 minutes, so 10 minutes in total on that front. I don't know how much time my learned friend would need on that issue, but it is a short issue. It does relate to the trial itself, but also in substance, but also in process. And part of the complainant's concerns that the process going forward is civil, and that incidences like this can be dealt with.
I don't know, Mr. Kasibodo, I propose that we adjourn, say maybe for 10 minutes, then you can deal with those issues, and then we can then resume and then deal with that issue at that point. Yes.
I'm so sorry, Your Lordship. I accept. Just on a practical point of view, Lordship, if I could ask that the media switches off their cameras and their transmission devices for purposes of the next 10 minutes, because what I intend to do is to fetch members of my client from outside so that they're able to view the footage, and that's going to help us in terms of process. So I would suggest, and I'll ask Your Lordship, that you direct the media switches of all the cameras and the microphones, including those ones of court. As the court pleases.
Thank you very much. I think media, you heard that. Let's give the process an opportunity to fairly deal with the issues. If there are any issues, you will have an opportunity to record what actually transpired as soon as we go into considering the issues. And this includes both the audio, the visual, and even the written. Those who are taking notes, it is ordered that you, for the time that counsels will be engaged with their clients in this court, unfortunately, we don't have enough space for them to go and consult. So they're going to end up consulting in this court. So from now on until we resume, this court becomes a consulting room for counsel. And during that period, any discussion, any footage, any evidence, any comment, any behavior that happens between counsel and their respective clients remains confidential and private and should be treated as such by everybody. Thank you very much. We're going to adjourn for 10 minutes.
Perhaps before I address you on the substance of the issues, let me first start by apologizing to the court for the delay. You'd given us 10 minutes, well over the 10 minutes. The reason for that is practical. I went outside to go get members of my client, and then we had difficulties with the security guard in terms of protocols and so on. So we had difficulties trying to get them in. As I understand it, some of them were sent to your chamber to get confirmation that they may indeed come in. Eventually they did. And we viewed the footage, and your lordship will direct us in terms of how we're going to deal with the issue. I've taken instructions on the issue. At least one or two of them are available to testify if it gets to that. I don't know if my lordship is interested in hearing what the version is. I would presume you'd firstly want to watch the footage, then perhaps make submissions afterwards, and you'll give a ruling in terms of how we're going to deal with this. And before I sit down and my learned friend responds to what I've just said, we would like to raise an issue as well, and just to place it on record, that your lordship directed, ordered, before we left this court, that no footage whatsoever may be taken during that process, because it speaks to privilege, it speaks to the issue of contempt of court in court. And to our dismay, your lordship, the witness who's currently an expert witness for the complainant was taking footage of the process while my clients were here, and you had ordered that that not be done. So perhaps let's deal with the first issue, and then perhaps you'll give us a directive in terms of how we're going to deal with that aspect going forward. As the court pleases.
Yes, Mr. Oppenheimer.
My lord, on the second issue first, my attorney informs me that the witness was on his phone but not taking photos. But that question can be asked to him about that. What I'd like to do on the major issue is to show footage from yesterday, and then have.
No, but sorry, he had a cell phone on.
Yes.
And he says what?
As far as I understand, in other words, he was using the phone for non-photographic purposes.
That's recorder.
It might be best, in other words, if you can explain to me. All I've been informed is that he used the phone not as a camera, but as a phone.
But my ruling was very clear, and I thought I emphasized that audio, visual, even writing, it's not permissible.
Yes,
because what your client has done was basically undermine that order.
I think that he should explain what it is he's done. It might be nothing other than looking at his phone as opposed to taking notes, recording with a video, or with photographs. In other words, he would be not in breach of your lordship's directives.
No, but if he used his cell phone to record whatever was being said, that's also breach of the rule.
My understanding is that that's not what occurred, but he may be much better placed than me to, in other words, he can explain what he was doing with his phone.
Look, I think, Mr. Oppenheimer, it's going to just drag this thing beyond the time that we anticipated, because I can almost anticipate other legal complications. Sitting here as a judge, looking at whatever has transpired, I'm not an expert on cell phones. Mr. Kasiboto will turn around and say to me, well, we need to go into a forensic check as to what actually happened. But the fact that somebody displays showing that he's actually, whether he was recording or not, but that gesture, that display in itself for me amounts to undermining the ruling of the court. Because if any of the media people started posing their pictures to you, even if they just switch it off and step back from their cameras, that for me amounts to undermining what the court actually was at pains to try and make sure that it covers everything else.
Yes, my lord.
If somebody gestures with a cell phone, we know cell phones can perform various functions. Now, we don't know whether he was recording, what he was doing. Even if you take a photo, you'll never know how you take photos. You can turn these things upside down and they'll perform whatever you want. So it will be him alone who would know what he's doing. But all I'm saying is speech and gesture and writing, all of them fell within the perimeters of the court's direction that nothing should be done. And I think if he wished to do that, he had all the right to come to you and say, this is what I'm doing. Could you ask the other side to allow me?
Yes. Well, my lord, in other words, if it may be the case, and Mr. Roets must explain, that he looked at his phone like I'm looking at it now to read something, and that there's no recording going on, there's no transcription going on, that people look at their phones for all sorts of reasons, and it could have created, I understand I could create the impression to a third party the phone is being used for recordal purposes.
Okay.
But there was no prohibition on anyone looking at their phone.
Okay. Mr. Gasibuto, what's your view on
that? Your Lordship, my response is this. I wish to take the matter no further except for to say this. I find myself in a precarious position because not only am I counsel, I'm now witness, along with my attorney here. What transpired, Your Lordship, as we're coming in from outside, I was informed that Mr. Roets is taking footage of the process while my clients are here. I then asked Mr. Roets, why are you taking footage when it's not permitted? His response to me is, well, I can delete them, I did not know. My attorney is witness to that, and I can identify individuals there who are witness to that. Now, I will invite Your Lordship to give us a ruling where I'll call specific individuals here to come and testify under oath as to what happened. I will call my witness to testify under oath what happened, and then I suppose we can take it from there. And the point being made that it's under oath, and the consequences that follow should someone perjure themselves in your presence will follow.
Okay.
As a court, please.
Yes, Mulder, I think the simplest way to do it is to say, I'm not a witness to it. Mr. Roets can explain exactly what the situation is regarding that issue, and but maybe that should be dealt with first, and then we will proceed
We'll deal with it. Okay, thank you very much. Okay, can Mr. Botha come forward?
Mr. Roets.
Is it Mr. Botha or Mr. Who?
Mr.
The one
Roets.
who was holding the cell phone?
Yes.
Okay, can he come forward, please? Oh, that's Mr. Roets. Okay. Good morning, sir.
Good morning.
I know you are a witness that's still on the stand.
That's right.
I would take it that that oath would still continue to bind him. I don't need to administer any further oath. So, Mr. Roets, you still under oath in terms of the main testimony that you put forward as an expert, and you are about to go into cross-examination. Now, an issue has arisen that relates to the ruling that I made earlier. Now, I didn't type out that ruling, but I recall it quite well, and the record would reflect that I said and I emphasized that the media should not record what was going to happen in the court because both parties do not have any other venue where they could privately consult with their witnesses. And therefore, this court, in a sense, I turned it into a consulting room for both parties. And that no audio, no visual, no written recorder of what is happening. Now, it seems to me that would imply also recordal by way of a cell phone. Now, you have been accused that or a complaint is being laid, let's not use the word accused because it changes the picture. There is a complaint that you were seen with your cell phone or on your hand, and the interpretation given by counsel for the respondents is that you were taking a footage during that particular process where such conduct was prohibited. And so I will then allow Mr. Oppenheimer to take it from there then.
Mr. Roets, first, if I can ask you, when you displayed your phone, what were you doing?
Yes, I took out my phone. I can explain to you the context and also what I heard the judge say from the back. But I did take out my phone and I did take a photo.
Could you explain the context?
So what I heard the judge say, firstly I should say that it's very difficult to hear up to the back what is being said in front. The judge might have seen people sitting at the back like this. I heard the judge say that there will now be time for consultation, that we're going to take a 10-minute break so that the legal teams or representatives and their clients can discuss what they should do. One of my colleagues at the back said to me that he understands when the members of the respondent came in that he thinks what the judge said or what he heard one of the attorneys said is that I'm going to have to identify the people who were outside and to see who of them are here. I'm not sure if that is what the judge said or if that is what is expected of me. So I was sitting at the back looking through footage that was taken yesterday, trying to identify which of the people who are in court were here yesterday as well. And I think I could identify one person. And I was sitting at the back and I saw at one stage I saw they were standing in a group, and I thought it would be appropriate to take a photo so that I can compare the photos from yesterday with the photo taken from today to make it easier for me to identify who are in fact here today, whether it's the same group of people as who were here yesterday.
Do you have any intention of disseminating that photo publicly?
No, absolutely not. And in fact, I can say, just to correct what your learned colleague has said, he did not ask me why I took footage or whether I took footage. One of the clients, or his clients, said to him that this gentleman is taking, I don't know what he said, he was pointing to me. And I stood up and I said, I took a photo. I don't think a footage and a photo is the same thing. And I asked him, am I not allowed to take photos? Would you like me to delete it? And I don't think he answered me. So I assumed that that implies that it's better to delete the photo, so I didn't delete it.
So the photo has been deleted?
Yes.
Yeah. And if I understand, is it your evidence that the purpose of taking the photograph was for your testimony that you will be giving now about the nature of the incident, not to report on what?
Yes, to be able to look at who are the people who are present today at the proceedings, and to try to determine whether the people who are here today are the same people who were here as who were here yesterday.
I understand. My Lord, I hope that clarifies the issue.
Your Lordship, I don't know whether we've gotten to a point where we're actually making...
Beg your pardon, my apologies.
Is Your Lordship in contempt of his order?
Yes, I apologize. I'm so sorry.
Your Lordship, I don't know whether we are at a merit stage or not. And as I've intimated earlier on, I find myself in an unenviable position on both counsel and the witness. What I'll perhaps do for Your Lordship's benefit is this. Pose a couple of questions to Mr. Roets about his testimony just now. And then Your Lordship is going to give a directive in terms of what we're going to do about it going forward. Now,
well, let me ask you this question, Mr. Kasibutu. He seems to now concede
Yes.
that the cell phone was used.
Yes.
Now, how far would it take it to?
It's one question, Your Lordship. It's a
Okay.
question of intention.
Okay, go ahead.
Mr. Roets, how are you?
I'm fine, thank you. Yourself?
Thanks. It's Mr. Gaspoto in court, by the way, not the son. Mr. Roets, you intimated that you had no intention of disseminating the footage, or rather the picture. My apologies. Not so.
That's correct.
And is the question of intention relevant for purposes of contempt? So in other words, must you have intention to breach a contempt, or rather an order of court?
I don't think so, no.
Yes. And
Sir, I don't hear Mr. Roets.
I said I don't think so, no.
it comes across as striking, Mr. Roets, that you would suggest that you did not hear the entirety of your Lordship's order. In light of the fact that since the very first day of this trial, your Lordship was at pains about protocol in court, what ought to be done, what ought not to be done. In one instance, we had an instance where we had to adjourn precisely because of these issues with compliances. I find it quite striking then that clearly your Lordship is giving an orders to the conduct of the court going forward. You nonetheless don't take it upon yourself to find out what exactly the order is, despite all the concerns that have been raised by your Lordship. My suggestion and my submission will be in due course that that is highly improbable. You must have heard what is being said. It's highly improbable that of all the people that were around you did not advise you as to the unlawfulness of what you're doing. Do you have a comment in that respect?
Yes, I do have a comment, and that is that I'm aware of the fact that I'm under oath. So it is indeed the fact that I could not hear properly what my Lord said, and it is indeed the fact that I did ask my colleagues what the instruction was, which is when one of my colleagues said to me, he understood that the judge said that I'm going to have to identify the people from the video. And that is the context. That I did make an attempt to find out what the exact words of the judge was. I have to be honest with you, I'm still not sure if I am going to have to identify the people or not. It's just a colleague said to me that's what he believes might happen.
And that's the entirety of the entire group. So what you are suggesting now is, what you've just given us now is the sum total of what everyone at the back had.
I don't know if it's a sum total of what everyone at the back heard, but it's not the sum total of what I discussed with my colleagues, but I think it's the most important part.
No, absolutely. Thank you, Mr. Roets. As the court pleases.
My Lord, just on this issue, from what I understand your Lordship's ruling to be aimed at is to provide the respondents with an opportunity to have a consultation space, that the press would not report on the contents of that consultation, that your Lordship's order was directed at the press. It appears from Mr. Roets' evidence that there was no intention to either intercede, in other words, intervene in what the contents of that consultation was. It appears that it was to see if the people that were present were the same people that are present in the footage that is to be shown. It appears that there is no breach of your Lordship's order, nor any intention to breach it either. My Lord, I submit that this is a distraction. The main issue that should be dealt with really is what happened yesterday, which I'd like to get onto, and it is of concern.
Thank you very much. I think let's deal first with this issue and put it aside. As I understand, the proposition made by Mr. Kasiboto, counsel for the respondent, is that this court should make a ruling in relation to the conduct of Mr. Roets. And as I say, would you agree with me that let's deal with that first before we go to the video?
Yes, my Lord.
Okay, thank you very much. At the beginning of the hearing this morning, it was brought to my attention by counsel for the complainant that there was an issue that arose yesterday afternoon involving himself and the witness that is on the witness stand, Mr. Roets. After a brief address, I ruled that I would rather both counsel discusses as to what approach should be adopted in dealing with that, more particularly the issue of whether the other people that are subject of that complaint know about the complaint and may want to respond to it. It then dawned to me that the reality was that there was a need to adjourn the court to afford both counsel an opportunity to consult with their client for the purposes of preparing how the complaint should be dealt with by the court. The essence of the direction given by the court was that there was a need to afford those against whom the complaint is directed at an opportunity to hear what is it that is being complained about it. A very basic and fundamental tenet of our broader law and the Constitution, that when a person is accused of any wrongdoing, that person must be afforded an opportunity to hear first the complaint and its nature before he or she can respond. I then indicated that because of the time pressure and the wish that we proceed with the main case to bring it to finality, directed that 10 minutes would be allotted to the parties to consult with their clients, and after that to indicate how they would wish to proceed. There was a request from one of the counsel that because the courtroom was going to be used as a consulting room, that the media should switch off their cameras. I then made a ruling, the essence of which, and I must just indicate, I did not draft the ruling. I made it at the top of my head, but I believe it was an appropriate ruling whose essence was that media was directed to switch off their videos and also the audio, which means the recording of the proceedings. I then, in the process of making that ruling, emphasized that this include also written or note-taking that may happen during the proceedings or during the consultation by counsel with their clients. I did not specifically refer to the issue of the usage of cell phone, but I think it goes without saying that the reasonable interpretation that can be given to the order was that cell phones would fall within that category of recordal or typing or any form of taking notes of that private and confidential discussions that would take place between counsel and client. It then transpired when I returned to court that there was another complaint raised this time by counsel for the respondent. And the complaint is directed at the witness that is currently in the witness stand, the expert witness from the complainant in the main case, Mr. Roets. The complainant is that at the very beginning, when counsel walked in to consult with clients in court, in the courtroom, they noticed that he was in a process of using his cell phone. It's not very clear in the complaint whether there was any specific usage of the cell phone. But in short, it was then agreed that Mr. Roets should take the stand and testify under oath as to why he used the cell phone. Essence of the complaint, although not that fully articulated, seemed to me to be that in doing what he did and observed by both counsel and the attorney of the defendants, he was in contempt of the court order. The rule relating to, or principle relating to contempt of court is quite clear in our law. And I don't have the citation at the top of my head, but I think the well-known and famous case of Faki, which has been cited by various courts, including the Constitutional Court, sets out what constitutes a contempt of court. One of the essential elements is that the court order ought to have or should be served on the person accused of contempt of court. It would seem to me, if one was to interpret that approach in the context of what happened in this case, it would mean, because the order was not in writing, the order was never served in a sense of being served as a document, it would mean anybody who was sitting in the court and listening to that oral order would have received the order. Mr. Roets testified that indeed he was sitting in court when the order was made. However, he says he was seated right at the back of the court. The courtroom is a very large court. In fact, it's the largest, I think, amongst the courts of this court. And there is indeed a distance from where the judge sits to the people sitting at the back. He says he heard when the order was made. However, he couldn't hear everything else which was said, and that as soon as the order was made or soon thereafter, he spoke to some of his colleagues to understand what the court had said. He says he couldn't hear that he was prohibited from using his cell phone. And he says that he used the cell phone for the purposes of looking at, taking a picture of the people on the side of the defendant to see as they come into the court to consult with their counsel as to whether any one of them includes people who are involved in a complaint which is about to be heard and about to be displayed on the screen relating to the incident that occurred yesterday afternoon. That's what he says, that's the purpose for using the cell phone. I should indicate that looking at the facts as they are presented, one is tempted to immediately say that it amounts to contempt. But I will come back to that in a moment. But to say that the conduct itself, and I think Mr. Roets also in a way considered during his testimony that it would have not been permissible and it would have been wrong, but that he did not do it intentionally. In my own analysis of the evidence before, let me also just pause here and indicate that counsel for the defendant had indicated that he had intended to also call his attorney because both him and the attorney observed the conduct of Mr. Roets. And thus he had indicated he was intending to call her to testify. That never happened, and neither did he call any other witness to contradict the version presented by Mr. Roets in any case, Mr. Roets did not dispute the version put forward to him by the counsel for the defendant. So calling a witness would not have necessarily taken the matter any further. In my view, yes, indeed, one can criticize Mr. Roets, and one could also say, Mr. Roets, you ought to have known better, being an expert witness, having written on some of the subject relating to complaints about conduct of people, and I think also taking into account what Mr. Kasiboro said, that this court right from the beginning has insisted and will continue to insist that the court should be given respect, the decorum of the court should be respected, and any directive issued by the court has to be respected. And I pause here because this is a fundamental issue. And I have observed, both sitting in court and reading on the media and looking at some of the footages on television, how it looks like in this country, if we're not careful, we are going to end up with the court losing control of what is happening. We're gonna face a situation where lawlessness would be the order of the day in the courts. And the court would not serve the purpose, if that happens, which is been granted to it by the Constitution. And I personally wish to warn the country at large that if we're not careful and we don't take a firm stand on principle and simple things like walking in court and bowing, showing respect to the court, we will run into difficulties. And similarly, turning back to the issue of the complaint against Mr. Roets, if people are just going to disregard court orders in any manner, we may as well close shop, because the court will not serve the purpose that the people of the country would expect it to do. And those who are in authority in charge of ensuring the respect of the court and the respect of the rule of court, they, I would say from my side, be warned to say you'd rather start putting your heads together to say what is happening. In as far as the contempt principles are concerned, it's also an element or a factor that needs to be taken into account, the issue of intention to undermine the court. From the evidence presented by Mr. Roets, it doesn't appear to me that he intentionally disobeyed the order. When he was immediately confronted by counsel for the defendant, he indicated and says he inquired from him as to whether he should stop using the phone to photograph. He says he also indicated to him that if he so wished, he would delete the photo in the phone. I also take into account, and I don't think it has been disputed, that everybody who was seated where he was, and I may just mention that I saw him as he was called to come forward, that he was indeed seated at the second row in the seats at the back of the court. And thus I have no reason to doubt that he may not have heard fully the order as was given. And thus my ruling would be, or before I make the final ruling, yes, in fact, let me make the ruling. My ruling is one, the photo taken during the consultation between counsel of both parties by Mr. Roets need to be deleted, and they should be deleted in the presence of counsel and both attorneys of the parties. And Mr. Roets, you are also directed that if you took more than one photo, you are duty-bound, being under oath, to disclose all those photos. If there are any photos or any images that may remain in your cell phone, include anything that you may have typed into your cell phone if you did, all those should be deleted. But secondly, you also prohibited, if for any reason they are not deleted, to circulate them on any platform, including social media. Accordingly, I also find that Mr. Roets cannot be found guilty of contempt of court. Thank you very much. Yes.
As the court pleases.
We may now proceed to the next part of the case.
My Lord, I'd now like to lead the video evidence that was taken yesterday. Sure.
So yes, Mr. Kasiboto.
Just a practical point, Your Lordship, and it is this. As I understand it, there will be leading of evidence, and then I'd imagine I would lead evidence as well in response thereto, and perhaps there will be cross-examination. So with the court's leave, can you adjourn for 5 minutes so I can fetch one of the persons that might be of relevance? And the second, if Your Lordship is so inclined, can I request that a copy of Your Lordship's ruling in respect of the contempt issues provided to counsel for the respondent? As a court, please.
Provided to everybody. I'll speak to my secretary because, as I said, I had requested a running record. And just let me ask counsel, both of you could not resolve what happened yesterday between yourselves? Or is it so fundamental? I don't want to get you to go and mediate or negotiate a principled fundamental constitutional issue. If there is a fundamental breach of the Constitution, I am a believer that your negotiation and mediation sometimes would not be appropriate.
My Lord, I'd submit in these circumstances it's not appropriate for the parties to deal with it themselves. It must be on the court record.
Okay. Well, that being the case, then leave is granted to Mr. Kasiboto to go and fetch your witness. I understand you may be encountering problems in coming through the door. I'll request my secretary to just be next to the entrance so that he can facilitate so that you don't lose time and have that problem.
Yes.
Thank you very much. You said you want how much? 5 minutes?
5 minutes, Your Lordship.
Well, maybe let's just make it a tea break now. It's 20 to 12. Can we be back? Just say 5 to 12. No, it's not 25 to 12. Let's be back by, say, 5 to 12. 5 minutes to 12. Thank you very much. The court shall adjourn.
Do you want to quickly deal with the phone issue? I'm just comply with order and close it.
the short discussion we had with your Lordship in your chambers, the agreement was that I was going to bring a rescission application for the order that was brought, that was given by this court this morning, on the premise that we were not given an opportunity to make submissions, particularly in relation to the question of intention. It's for that reason that we bring an application for rescission, and process will follow thereafter. Of course, if court is minded to grant us the application. As a court, please.
My Lord, if my learned friend wishes to bring an application for rescission, we have no objection to him bringing such an application, just that it should occur within the ordinary time periods, and that the matter can be dealt with in due course.
Okay. I thought the agreement was that it could be brought tomorrow. Or are we now saying we'll fall back to the other point?
I think the position is that, in other words, because the consequences of a rescission being granted could be detrimental, that, in other words, the ordinary time periods ought to apply, that it has no bearing at all on this matter, and that there's no reason for
on the main
rescission
matter
to be dealt with in any urgent time periods. But the application should be brought, or can be brought by my learned friend.
Okay. Thank you very much. As discussed in chambers, I did indicate that it does seem to me that there is some basis for considering a rescission application on the point raised by Mr. Kasiboto, and therefore leave is granted to the respondent or defendant to bring an application to rescind the order which was made this morning regarding the complaint which was raised against Mr. Roets for using a cell phone in the court. The question of the time frames, I will discuss it with counsel as to when do we hear that matter. Okay, thank you very much. That's the order granted.
As the court pleases. My Lord, then I'd like to start off by showing the video evidence from yesterday.
Sorry
Mr. Roets, just to remind you that you still remain under oath even under this particular complaint. Thank you.
Mr. Roets, could you please describe in some detail what that footage contains?
Thank you very much. So, since this case started on Monday, we've been having trouble getting in and out of the courtroom to the extent that I believe it was Monday afternoon, security officers of the court at one stage wanted to organize for us to go through a different exit at the court. They said they were concerned that there might be an incident outside. I said to them that I don't expect an incident, and the lady then said, well, it's one thing for me to say we don't expect an incident, but there might still be something happening. And then on Monday, just as we were having that discussion, a group of the protesters outside left, so we went out. There was an incident on Monday as well, which I can testify about if you want, but what happened yesterday in terms of what is on this footage is we wanted to leave the courtroom. There was a group of protesters, I don't know, 20, I'm not sure how many, I'm guessing 20, who were at the gate. Initially they barred the gate, they were screaming stuff, I don't know what they were screaming, I couldn't hear. So there was a hold up. You can see on the footage there's people, it looks like there's a queue, a line of people waiting to exit. We stood there for a few seconds and then we sort of, tried to almost push them out just to keep walking, to leave the building. And as we were right in the middle of the group, some of them started swearing at us and screaming, and the group started chanting, "Kill the boer, kill the farmer." Then at one stage I turned around. I was carrying things and I had my cell phone also in my hand, and I was turning around, and one of them grabbed my phone and he seemed to want to run away, I'm not sure, but he grabbed my phone, he had my phone in his hand, and fortunately we were able to get the phone back. The police then intervened and sort of got the two groups, make sure that there's sufficient distance between us, and then eventually we were able to leave.
On the first day of this matter, video evidence was led of the respondents singing the song with the lyrics, "Kiss the Boer." Is your evidence that the lyrics that were sung yesterday was "Kill the Boer"?
It was very clearly "Kill the Boer," and it was not only yesterday afternoon, it was also during the course of the day. And if memory serves me right, it was also on Monday when that happened.
Is there a relevant difference between those two versions of the chant?
Well, I guess that's something that could be argued or should be argued in this court. To my mind, if you say "kiss the Boer," but you still say "shoot to kill," it still is hate speech. However, if you just blatantly say "kill the Boer," then you don't even have that argument to fall back on. And also, I think to me, if you sometimes sing "Kiss the Boer," I regard that as an acknowledgement that singing "Kill the Boer" is wrong. That's why you sing "Kiss the Boer."
frightened by white fragility. This is our heritage. This music.
We are not going to massage your feelings. We are not going to massage your white fragility, your white privilege. This is not happening.
This is not about a song. This is not about a song. This is about our history. It is our history that is on trial here today. It is our struggle's history that you want to denigrate. It is our struggle's history that you want to have us deny. It is not going to happen, not today, not in the future. You want to whitewash our history and pretend that it never happened. Well, guess what? It did. And remember, Tukulupun is not really about you. It is about the system. And for as long as we are here, it means the system is alive. Therefore, Tukulupun is a song that will continue to
Security. Well, look, good people, we've seen what can happen to the court. I'm going to adjourn and have to go and speak to the court manager and find out what's going on. Thank you very much. We'll adjourn for 10 minutes. Thank you very much. I think we should then start. I've just been told that there is now security at the door. Nuktula, I don't seem to see anybody there. There's a police officer. Okay. No, that's fine. That's fine. Okay, I think we should go back to our own task.
My Lord, I've just finished asking Mr. Roets a question.
Yeah, he should come forward. Mr. Roets, can you come forward, please?
Mr. Roets, I just asked you a question which you were in the process of answering before the interruption. Is there anything else that you intended on saying about, if I recall, the question was on whether there is a difference between singing or chanting the words "kill the Boer," as was chanted in the video that we showed today, versus some of the videos from yesterday which have the terms "kiss the Boer" in the context of "shoot to kill."
Yes, thank you. So the most important part of my answer, which I was busy finishing, so I'll just make that point, is that to my mind there's no difference between singing "shoot the Boer" or "kill," "kiss the Boer" as opposed to "kill the Boer" if the rest of the song is still "shoot to kill" and so forth, and you still make hand gestures imitating a machine gun, and you still imitate the sounds of a machine gun. But if there is a difference, if you sometimes sing "kiss the Boer," that to me is an acknowledgement that it is wrong to sing "kill the Boer." That's why you change the lyrics. And now, if you sometimes sing "kiss the Boer" and suddenly when you're angry you start singing "kill the Boer," to me that is worse, because then it clearly indicates that you know you shouldn't be singing this song, but you keep singing it despite the fact that you know it's wrong.
Do you have any concerns about being able to access the court and exit the court during the proceedings of this matter?
My Lord, yes, I do. We've had some trouble every day since Monday, getting in and out of the court. And people screaming and chanting things is one thing. It's annoying, and it's probably a violation of our rights, you could say, but people physically barring the gate is a serious problem. People disrupting the flow in and outside, into and out of the courtroom is a serious problem. And people, we've had a few instances of one of my colleagues, for example, was walking and someone held through a flag sort of over her head, so the flag was in her face as she was trying to. That to me is a serious problem. People can apologies for the language, but people screaming things like "fuck you" if you walk in and out of the court is a serious problem. And just being surrounded by people dancing and chanting things like "kill the Boer, kill the farmer" is a serious problem. And then people trying to physically take your property, grab your property that you are holding in your hands, which happened on Monday and on Tuesday, to me is also a serious problem.
Are you concerned about your safety and the safety of your team in entering and exiting the court?
Yes, we are concerned about our safety. We have been concerned since Monday, and we had that discussion yesterday, and we had that discussion today, and the impression we get is very clearly that it seems to deteriorate in the sense that we are under the impression that we keep being under the impression that we need to implement more measures to take care of our safety. So we keep feeling more and more unsafe, if that's what you mean with the question.
I have no further questions, Robert.
As the
Yes,
court
Mr.
pleases.
Kasu.
As the court pleases, my lord. My lord, there was evidence that was led in relation to the interpretation of the impugned song.
The
impugned song.
Okay.
Yeah. And I'm concerned that once I venture into that terrain, then it's a slippery slope, because the very subject matter of this case is precisely that song. And my considered view that it's a legal question rather than one of fact, except for, of course, to an extent whether the word kiss or kill was used. So for that, with that proviso in mind, I'll cross Mr. Roets on the questions I'll cross him on the understanding that that's the reason I would rather not go to the question of kill or kiss.
I'm not sure I'm with you. Are you saying you want question on, for example, there was a clip that was played now, and they were singing there. Are you saying you're not going to question on what was sung?
Yes, no, I certainly will, my lord.
Okay.
Particularly when I deal with my witnesses, rather. All I'm simply saying is I do not want to venture into the terrain of what the song actually means, whether it constitutes hate speech or not. All I'm simply saying is we're going to test the factual aspect of the issue and not necessarily deal with the legal submissions. Good afternoon again, Mr. Roets.
Good afternoon, Mr. Kasiboto.
You did say that yesterday, just prior to the incident that has been shown in the videos, you had responded to one of, I imagine, the security guards that you did not expect any incident. Is that so?
Yes.
Yes. And you would have said that precisely because you had no reason.
I didn't hear well, and I don't think I understand. Is the question whether you said the security, or you said there would be no trouble, or the security said there would be no trouble?
I'll rephrase the question,
Okay.
my lord. Mr. Roets, it was your evidence that in response to a security guard cautioning you about leaving court at that particular point, your response to that question was you did not expect any incident. Is that so?
That's correct. I just have to clarify that was on Monday.
It was on Monday?
Yes.
No, precisely. My correction, you're correct, yes. And the reason you said that was because there was no reason to believe there would be any incident.
Yeah, I don't know if there was no reason to believe. Maybe you could say that. I wouldn't frame it that way. I didn't want the security guard said to us that we have to leave through a different exit, and I thought that was quite inconvenient to arrange for the vehicles to pick us up at a different parking and for us to walk, which sounded to me like it was on the other side of the courtroom building, and I just wanted to go home. So I said to it, let's just use this exit.
Sure, and I accept that, but the proposition is slightly different. You must have then, that's the reasonable inference,
did try to do something. I believe it would be to their own detriment. So I expected that I cannot say to you under oath that I was completely convinced that there's no possibility of anything happening outside the courtroom. That's not what I thought.
Very well. I'm going to ask the question again, Mr. Roets. Bearing in mind the warning you got, excuse me, from the security guard, you take the decision to go through the gate that you've been warned about.
Yes.
Because you did not expect any incident. That can only mean there is no incident that is worth avoiding. Surely that must be the inference.
Yes, you can say that.
I have no further questions, Your Lordship.
Thank you very much. Re-examination, Mr.
Just one point of clarification. My learned friend's questions, I take it, pertain to the events on Monday and not to the events shown in the video from yesterday. Is that correct?
That's correct.
I have no further questions, my lord.
Yes, Mr.
Your Lordship, my learned friend has just advised it's lunchtime. My proposal to him And my proposal to court is that we deal with the next witness. It will just be one. I assume it's not going to detain us for too long. Thereafter, then we can take the lunch break.
So this witness will stand down.
This witness will stand down, Your Lordship.
Okay. And that's the witness still relating to the yesterday's incident.
Yes, Your Lordship, it will be a version dealing with the video.
Okay. That's fine. How much time do we need for, it's now 1 o'clock. We'll be back by 2 o'clock.
So, Your Lordship, what I'm saying is I'm suggesting that this witness stands down. I call the next witness, which shouldn't take more than 5 minutes. And then Mr. Oppenheimer, if he so desires, he will cross. And the re-exam will probably be a second.
Okay.
And then we can take the lunch adjournment.
Oh, okay, that's fine. But then let's make sure we don't slip off in terms of the procedures. Do I take it that for the record, Mr. Oppenheimer closes his case if you're going to be calling your witness?
Yes, my lord.
Okay, thank you very much. So the case is now closed on the complaint. Thank you. Okay, Mr. Kasibuto, you can call your witness.
Thank you, Mr. Roets.
Thank you.
State your name and name for the record.
Lwandile Ngwenzi.
Do you have any objection in taking this oath?
No.
Do you swear that the evidence you're about to give is the truth, the whole truth, nothing else but the truth? If so, raise your right hand and testify to God.
So help me God.
Thank you very much. You may be seated if you wish, but before then, can you just spell out your name for us so that we don't...
It's L-W-A-N-D-I-L-E.
L...
W-A...
W-A...
N-D-I-L-E.
Luandi.
Lwandile.
Luandile, that's the name.
Yes.
The surname?
It's N-T... W-E-N-Z-E.
N-T-W-E...
N-T... W...
Yes.
E...
Yes.
N-Z-E.
I hope the record will have it, but no, I do need to find to get the correct surname. It's N-T-W-E-N-T...
N-G. N-G, G for Gogo.
T for?
G.
Well, Counsel, can you help me?
Perhaps I was about to ask Mrs. Noktula if she'd mind just writing a note to judge.
Yes, thank you very much. Thank you. Ngwenze.
Yes.
Is that, am I pronouncing it correctly?
Yeah, we are
Ngwenze.
correct, yes.
Okay, thank you. Now, I do this because I see sometimes on the record people's names spelled in whatever way. Mine is even worse. Mine has got sometimes a G and an I and an N. It's one of those things. And Counsel does it, and I like it because some of them, even when they put up their draft orders, they'll put it with a wrong spelling. And I'll say, okay, thank you very much. I'm not the judge who presided over this matter, so go and find the judge. Yes. No, thank you very much, Mr. Ngwenze.
Good afternoon, Mr. Ngwenze. Well, just as a bit of protocol, you'll excuse me, Your Lordship. I just want to familiarize client with protocol on how to respond. It's something I overlooked. If you don't mind, can I consult with him for a second? My apologies, Your Lordship. Thank you, Your Lordship. Good afternoon, Mr. Ngwenzi.
Good afternoon, Mr.
Were you present in court when the video footages were being displayed in court earlier?
Yes, I was present, Mr.
Yes. Were you in the video?
Yeah, there is in some of the videos where I appeared. Yes, Mr.
Okay. And who were you with at the gate?
With the members of the EFF, Mr.
Is it?
Yes.
Were all individuals in the...
Just face the court so
Okay.
that I get your voice.
At what point did you lose him, Your Lordship?
Sorry?
At what point did you lose him?
No, I got him all, but just that he's speaking a bit. He
Okay.
says, the question was, were you at the gate?
Correct.
And says he was.
Correct.
Yes.
Who were you with at the gate?
I was with the members of the EFF, Mr.
Were all the individuals that were with members of the EFF?
No, not all of the members of the EFF, Mr.
On the video footage that was shown in court earlier, were you able to identify a person or persons that are not members of the EFF?
Yes, I can identify, Mr.
I don't know, unless my learned friend would want to raise a dispute around this. Rather than replaying the footage, I'll just ask him to describe the person he's referring to.
Okay, go ahead.
The person you've referred to as not a member of the EFF, do you want to describe him to court?
I can describe him to court, yes, Mr.
Then perhaps identify him by the clothes he was wearing.
Yes, I can also identify him by the clothes he was wearing. But the problem, Mr., it was not one person who was not the member of the EFF.
Okay, that's fine. Describe the first one by the clothing they were wearing.
The other one on Monday was wearing a black three-quarter and a black T-shirt with a cut. Yeah.
Black?
Black three-quarter and a black T-shirt with a cut, my lord.
Was there any other person who was not an EFF member?
Yes, Mr., but I cannot remember all of them because I was not marking up on that. But I can remember one or two, yeah.
Okay. So you've testified earlier that you were at the gate on the footage of the videos, were you not?
Yes, Mr.
Why were you at the gate?
We were singing outside the gate. Then while we were singing, a security guy wearing a camouflage clothes of Mabotwane approached us and told us we must move besides the gate. There are people who are going to come outside. Then we questioned him, why must we move aside? Because people have been going in and out. Who is so special that is going to come outside? Because people have been coming outside and have been going inside. So who is so special that is going to come outside? Then after we asked the security guy that question, he sweared at us. He called us rascals. When he called us rascals, he also promised to beat one of our own. When I say our own, I'm talking about the members of the EFF. He also promised
just
to beat
hold on
one.
there. Just hold on there. So for the benefit of the court, just pace your speech, and if you don't mind, answer in short sentences and directly what I'm asking you.
Okay.
And it would be easier to deal with it that way.
Okay,
I'm going to get to the point where you deal with that question.
Okay, Mr.
So you say there was a security guard at the gates at the point you were at the gate.
Yes, Mr.
Yes. How close were you to the gate?
We were not so close to the gate to such an extent that person can't go in or can't go out.
Yes. And where were the security guards at that point, particularly the one you made reference to?
The security guard came from outside, others came from inside, others were outside. Then the security guy who approached us came from inside.
Okay. And then what happened? So I imagine there was that discussion happening at the gate. Then what happened?
When When the security guard approached us to move to shift next to the gate, we asked him a question: why must we shift? Because people have been going in and out. Who is so special that is going to come out of the court?
Yes.
The security.
Now, just hold on. Sorry. And then, as that discussion is happening, are there people that were coming out of court?
No, at that moment there was no one. There were regular people who were going in and out and were not complaining.
Okay. And then, did the witness who just took the stand now approach the gate at any point?
By the time the security guard was approaching us or talking with us, no, I didn't see him. He came later when we were busy arguing with the securities.
So at the point you're arguing with the securities at the gate, the gentleman who had just taken the stand now, he approached the gate?
He approached the gate, yes.
Was he with anyone?
Yeah, he was with other people. He was not alone.
Yes.
But they were not walking on the line. Others were coming behind, but he was not alone.
Yes. Are you able to identify any of the persons that he was working with? Are they present in court?
Mr. I think I saw most of the people who are here, but I can't compare who went out before, who went in before.
But you can confirm that the people that he was with are in court, at least some of them?
Yes, I can confirm, Mr.
Okay. And then at the point, his name is Mr. Roets, so I'll refer to him as Mr. Roets. Yes. At the point Mr. Roets approached the gate, what happened?
At the point Mr. Roets approached the gate, we were busy arguing with the securities. Sorry, I forgot his name. Mr. mentioned the same words that were mentioned by the securities to call us rascals. And he mentioned some words. Thank you, my lord. He mentioned the same words he uttered the same words that were uttered by the security that we were busy arguing with. Called us rascals and mentioned some Afrikaner words which I don't understand. But from the mere look of the...
Sorry. Okay. Thank you. Sorry, my lord, just before I continue the questioning, for the sake of respect to Mr. Roets, rather than just being referred to as a Mr., I'd suggest that the witness refers to him as just the witness and there's common understanding is referring to Mr. Roets.
Okay.
So just call Mr. Roets the witness.
Okay.
So you're saying the witness then approached the gate and he uttered what words slowly?
He called us rascals and some Afrikaner words, which I don't know. I can't even remember them because I don't know Afrikaans.
Yes.
But
just hold on.
Okay.
Do you remember his demeanor when you called you the Afrikaans words? In other words, how did you look?
From how I looked, he was swearing because he was angry.
So let me understand. You don't know what he was saying, but you could tell by his posture and demeanor that he was swearing at you in Afrikaans. Is that the evidence?
Yes, sir.
Okay. And then what happened?
Then when Mr. Rewards uttered those words, we said to him and the people he was working to, we called them racists. And then it started to be a war of words because they were calling us with names that I can't understand because they were talking Afrikaans.
Yes.
Then that's when the verbal attack began because they were calling us words, words that I cannot interpret or even mention because it was Afrikaans.
Okay. Now, tell the court, at the point there was this altercation you're making reference to, were they still inside the premises of court or outside?
They were still inside the premises of the court. Yes, they were still inside the premises of the court.
And then we see footage from outside of the court. Can you confirm that you're part of the people that were in the footage outside of court?
Pardon?
The question I'm asking is, the footage, the videos we saw, some of the footage shows incidents outside of court, in other words, away from the gate. Can you confirm that?
What happened, the securities and the police came to make peace.
Yes.
Then they went out because we were arguing with them inside. When they went out, Mr. Rewards took out a cell phone.
Yes.
I don't know whether...
Just hold on. Okay. Yes. So there was a point that left the premises.
Yes.
Now, before we get to the cell phone, is there any incident that happened in between? Let me phrase it this way. How did Mr. Roets and the cohort that he was with leave the premises?
The police had to come in and make peace because the verbal war was brewing.
Is it? And that's how they eventually left?
Yes.
Okay. And then tell us about the incident you were referring to about Mr. Roets.
Mr. Roets, when they were going outside,
Yes.
took out a cell phone. We went back to see him. He took out a cell phone, he videoized. I don't know whether he was videoizing or shooting at us, but he was carrying a cell phone.
Yes.
Then one guy, I don't know his name,
Yes.
one guy approached Mr. Roets
Yes.
to tell him, "Hey, Baba, stop what you are doing."
Yes.
Then Mr. Roets, I don't know whether the securities of the police were accompanying them or what.
Yes.
Stop what you are doing.
Yes.
Then they attacked each other verbally. Then Mr. Roets, there is a time when Mr. Roets turned like he wanted to be physical because it was verbal, it was not physical.
So did you see that with the footage? In other words, Mr. Roets turning and approaching someone?
No, I didn't see it on the footage.
Okay.
Yes.
Is this an account you had?
Yes.
Okay. But you were still part of the cohort that was outside?
Yes.
Okay. Now, when you say they left the premises and the cops, or rather the police, helped you out, were any of you involved in moving the people that were blocking the gate?
Yeah, some of the EFF members helped the police to end that hot conversation that was brewing.
Yes. Okay. Your Lordship, I've had a discussion with my friend about the issue of the witness confirming the evidence, well, the hearsay of one of the witnesses. He suggested he takes no issue, he can take it that it's confirmed. Just by way of the last point I'm making, Your Lordship, is this. One would appreciate that the witness probably saw the video footage once, which was earlier today. I do not know whether we'd have to play the footage again, but his version to the effect that he didn't see Mr. Roets turn and approach someone because he personally didn't see it. I can, however, confirm there is such footage, and to an extent there's a dispute in that regard, then you can have reference to the footage. And at that point, I've concluded my evidence with the witness.
So now, just still recording Mr. Genze. You said that at that time some EFF members, I just want to make sure, you say some of the EFF members intervened together with the police.
Yes.
Sorry, my Lordship, there's just a tail that I need to fix here in relation to one particular aspect. Sorry, Mr. Wenze, just one thing. So you've testified that there was an altercation, there's a point Mr. Roets was taking what you believe would have been footage or a picture. That was your evidence, correct?
Yes, sir.
And you say that one of the people that were around tried to stop him from taking the footage, is that correct?
Yes, mister.
Yes. Now, did you see that happening personally?
Yes, I saw it happening personally.
Okay.
Yes.
Did at any point, in other words, the person you're referring to as having stopped Mr. Roets from taking footage, did he at any point dispossess Mr. Roets of the cell phone?
No, sir. No, sir.
And you say you've got a personal account of that. In other words, you saw it yourself.
Yes, sir.
Thank you. I have no further questions, Your Lordship.
You're a member of the EFF, is that correct?
Yes, sir.
Did you take part in blocking the exits from court into the street?
No, I don't, sir.
Did you see other members of the EFF blocking the exit?
There is no member of the EFF blocked the exits.
When you saw that video, you make mention of two people who are not members of the EFF. One is a man in black and one is someone else.
Yes.
Is it your contention that the man in black was the only person who was blocking the exit?
I never said he was blocking an exit.
So was no one blocking the exit?
No one was blocking an exit.
No one was blocking the exit?
Yes.
When you saw the video and you saw Mr. Roets and myself and the other lawyers on the one side of the court building and EFF members at the gate, what was occurring there?
Pardon, sir?
What was occurring? Were we given free passage to exit or not?
When you and Mr. Rewards approached the gates,
Yes.
Mr. Rewards sweared at us. We were.
I'm asking if we were given free passage to exit. Could we leave at our own will, or were you and the other members of the EFF stopping us from leaving?
No one was stopped to leave, sir.
No one was stopping us.
Yes.
So when you see the video and you see a group of 25 people blocking a very narrow exit and physically pushing against the police and the private security, is it your contention that you are not blocking the exit?
Yes, sir.
I will put it to you that that is detached from reality. How do you understand the term blocking an exit?
Blocking an exit is closing a gate and refuse someone to go out. That is blocking an exit from my own understanding.
Yes, so now you know that gate has two gates to it.
Yes.
Did anyone from the EFF move one part of those gates to stop Mr. Roets and the rest of us from exiting?
No, sir.
Did they stand in the space between the metal gates and stop you from exiting?
Yes, they were standing in the middle of the gate, yes.
They were standing in the gate.
Yes.
Could Mr. Roets freely exit through the crowd?
If he wanted to exit, he would exit.
Did you take any measures to physically stop the exit? Or did you, as soon as Mr. Roets and the rest of us wanted to exit, did you part ways or did you stop?
No, we stopped because we were busy arguing with the securities, and Mr. Rewards, we were arguing with also Mr. Rewards because Mr. Rewards came and insulted us there.
So you're saying you were insulted, but did you stop him from exiting?
No, we didn't stop.
You didn't stop him exiting. All right. I won't push the points any further. When Mr. Roets eventually was allowed to exit, you engaged in singing and chanting the words, "Kill the Boer." Is that correct?
No, that is not correct.
Did the crowd sing and chant, "Kill the Boer"?
I think my counselor will address on that issue.
You're the one who's testifying right now.
Okay.
Did the crowds say that or not?
They never sing "Kill the Boer." I never heard them singing "Kill the Boer."
My lord, I have no further questions for this witness.
I didn't hear the last answer. Can you just give the last answer?
We were singing "Kiss the Boer," not "Kill the Boer." No one was singing "Kill the Boer."
Sorry, so you said the first answer was no one was singing. Your second answer is you were singing "Kiss the Boer," not "Kill the Boer."
No one was singing "Kill the Boer."
No one was singing "Kill the Boer."
Yes.
When video footage was shown to this court but moments ago, what did you hear in that footage?
I heard people singing "Kiss the Boer."
Yes.
Yes.
Do you have any hearing impediments?
Pardon?
Do you struggle to hear?
No, I don't.
So you hear normally?
Yeah.
So when you heard that video, you're telling me now, honestly, under oath, that you heard the words "kiss the Boer."
Yes, that's what I heard.
Yes, okay. And so what you heard on the day, yesterday, what you heard in court was the identical of "kiss the Boer."
Because that's what I was singing. That's what I heard.
Okay. Now I put it to you that every single person in this court watched that video and very clearly heard the words "kill the Boer" being sung. Is it still your contention that the words "kiss the Boer" were being sung?
Pardon, sir?
Every single person in this court watched that video, and every single person in this court could hear the words "kill the Boer" being sung repeatedly. Is it still your contention that the words being sung in that video are "kiss the Boer"?
Yes, it's "Kiss the Boer," not "Kill the Boer," sir. Okay. The last time.
My lord, I have no further questions.
Thank you. Re-examination.
So just to confirm, your evidence when you were being cross-examined by my learned friend was that you understand that there's a difference between blocking the gate and standing at the gate.
Yes.
What you deny is that, okay, let me take a step back. Perhaps let me just go there, actually. So what you understand is that when someone says you're blocking the gate, that means you're preventing someone from leaving.
Yes.
Whereas when you are standing by the gate, you're not necessarily blocking. That's your understanding of the word block.
Yes.
Okay. And you also say, if I heard you correctly, that you heard kiss the boer and you heard nothing, well, no one sing kill the boer, is that correct?
Yes.
And you're saying you take that view because the words you were actually singing were kiss the boer.
Yes.
Now, let me ask you this. Was there any noise in that area at the time, take into account what you attested to earlier, which is there were people shouting at each other and there was singing? Does that mean there was noise in the area at the time?
Yes.
Yes. And all you could hear was kiss the boer?
Yes.
No further questions, Your Lordship.
Sorry, you said that one person engaged in a verbal exchange with, I take it was with Mr. Roets.
Pardon, my lord?
You're saying that someone engaged in a verbal exchange, and I take it was with Mr. Roets, one of the people amongst the crowd.
That's correct, my lord.
And then this person asked, Mr. Roets then took out the cell phone, and this person asked, what are you doing in taking the footage?
Yes, my lord.
Okay. And then you also say that from the footage we've seen here and listened to, the only word you heard was kiss the boer and not kill the boer.
Yes, my lord.
The other clarity I just want to seek from you is, did you say you were also singing, or you said you only heard?
I was singing.
You were singing?
Yes, my lord.
Okay. Just going back to the gate, you say initially you engage with a security officer who said to you that there are people coming, you must move away.
That's correct, my lord.
And then you debated with him as to who are these people and why should we move away. And then at some point, Mr. Roets approached the gate, and then he called you what?
He called us rascals, my lord, and some
What?
rascals and
Rascals.
some Afrikaner words which I couldn't understand and I can't
Okay.
even interpret.
Just give me one thought. He called you rascals and used another Afrikaans word. Okay, I've got that. And at that stage, they were still inside the courtyard.
Yes, my lord.
Thank you very much. Any follow-up question for my questions?
No.
Thank you, Mr. Namba. Mr.
None from me.
Thank you very much. Mr. Gwenze, thank you very much. You are excused.
Thanks, my lord.
Right. Would it be an appropriate time for us to take the lunch break, and then we'll proceed with the cross-examination of Mr. Roets after lunch?
Yes, Lord. Just one thing I should maybe say at this juncture.
Sorry.
My Lord, with regards to this episode, it's our contention that it should be a part of the main proceedings in the sense that they're intimately connected. But there is another reason which it was led, is that it is vitally important that these proceedings are conducted in a manner that is civil, that all parties, the legal representatives, and all witnesses feel safe in being able to enter and exit the court. And while they're in the court itself, we've already had an incident of people protesting in the court. And so we'd seek a directive on that front, just so that the proceedings can proceed in a peaceful manner. Inside the court precinct might be the better way of describing it, not merely this particular courtroom.
Thank you. Mr. Sibuto?
My Lord, in relation to the suggestion that this incident formed part of the process, we'll of course oppose that. No application of a sort has been brought. What we have are pleadings, and we are proceeding on the basis of those proceedings, rather. To an extent, my learned friend wants to introduce this as evidence and form part of the record, then a proper application should be brought in that respect. As a court, please.
Mr. Bonama, your response to that?
My Lord, I would submit it is on the record. The nature of equality court proceedings is different in that the Act describes them as informal proceedings, that the rules of evidence are different. It has clearly been seen by the press. It would be strange to exclude it from the evidence. It is evidence of the EFF singing the songs "Kill the Boer" and then denying it under oath. Of course, it must form part of these proceedings. If a directive as to how to amend the papers to include them needs to be issued, then so be it. I think it is mentioned in our papers that we would include, we make reference to a series of songs and series of speeches. The evidence bundle has been updated throughout these proceedings, and I would submit that this is part of that evidence.
But my understanding was at the beginning, this was being brought in. I just want to look at my notes. It was an application, it was a complaint lodged by the applicant in the main case concerning an incident that occurred on Tuesday afternoon. And in fact, what I wanted to understand, because I wasn't too sure as to what direction it's taking, was, and then I was anticipating that both parties will address me as to what relief should I grant in relation to the evidence that's now before me regarding Tuesday. And one of the questions that I had thought I would ask you is, the complaint itself doesn't say what is the relief relating to Tuesday. But it seems you now say the whole evidence as it stands should then be admitted into the main case.
Yes, in other words, it may be that because the words themselves are used, it might be premature to make a judgment about the content of those words. It's just, as I said, the second part of my statement.
He then stood and spoke of evidence. At that very point, I interjected and I said, well, once you start talking about witnesses and evidence, the record will show. Then we are venturing in a whole completely different terrain. And I specifically said, I'm not too sure what process we are now following once we start talking about evidence and witnesses and cross-examination and so forth. But I was happy to proceed with the process for the sake of the ruling, which is the very first statement that I made, that my understanding, this is just about a ruling in terms of how court process will proceed and security measures and so on. To the extent now there's a suggestion that this should form part of the record for purposes of trial, there's clear prejudice here. I've merely consulted with the previous witness for a space of 15 minutes, and now suddenly it's going to form part of the record without proper preparation, without proper consideration of the evidence. That is clearly prejudicial, particularly if I move from the premise this is solely for the purpose of the ruling. For that reason, Your Lordship, I insist that an application must be brought. As the court pleases.
Thank you very much. I think I'd like to deal with the issue of the safety and the freedom to participate in the court proceedings. Let me indicate that we had an incident earlier on. I have, during the adjournment, had an opportunity to discuss with the court manager, and she has assured me that she was going to attend to whatever may have been the lack of security, because from my side, I was expecting that if there's any incident, anytime, including as we're sitting here, security should come in immediately. Security came in, they stood next to the people that were singing. I tried to call them, I'm sure everybody heard that. She never even looked to the side of the judge to see what is happening. My observation of the security officer, she never even looked to observe if there were any other disturbances, if there was any trouble that any one of us sitting in this court may be facing. She actually left without even looking to the side of the judge. Now, I thought, in my simple knowledge of security, you walk into a place where there is some disturbances, you try and establish what is going on. But I saw the two ladies leaving with their placards freely out of the court, and as I sit here, I'm not even sure whether they were ever called to say what you were doing was wrong. And what I sought to call the attention of the security for was to say to her she must call them to come to the front, and maybe they had an explanation to give to me why suddenly today they were doing what they were doing. And I would have loved to hear from them why they're not respecting us. Everybody seated, everybody is quiet. They simply burst into a song. But be that as it may, as I say, I have spoken to the court manager, and I would hope that the situation is now under control. I was assured at the beginning of the week that in as far as crowd control is concerned, that also has been put in place. So as I said here, I was quite confident that every single person who has decided to come to this court would feel free and feel safe. I would urge everybody, both the parties, in particular the main role players in this dispute, to act with restraint. I recognize that a dispute of this nature would raise emotions, tempers, and tensions. But I think if we have agreed that the court is the final arbiter in terms of the differences between ourselves, give that opportunity so that you can resolve the dispute in the most amicable way and in terms of the rule of law. So I would say, I urge, and I would not expect from any one of you sitting in here to undermine each other, to provoke each other. But also, I think some of the people out of this court are your members upon whom you have influence. I think you need to also take responsibility to bring them to order. And both yourselves has actually brought attention to the public for them to come here. Any other person who's not your member and suddenly joins in to take advantage of the situation, I think you also have an obligation to deal with that person. And at best, I would say, if you can't deal with that person in terms of reprimanding and calling them to order, you may want to approach the police and indicate to the police, this person is not our member and is here simply to come and cause a trouble. So as far as I'm concerned where we are, we should be able to proceed with safety. If there's anything else, the court manager has promised me that she will address this issue and make sure that it is properly controlled. And if I may also say that if security advises, please take the advice. These are people who are trained. These are people who understand the situation, and I would take it working with the police, they would have analyzed the situation. So please, if they say to you, today we're not going to allow you to enter here, we're going to enter there, please take their advice. And I would say all of us should listen to what they say. Okay, I think that's all what I would say. I think then in terms of the case itself, the complaint which was lodged today, or for which evidence was laid, I think that I would stand it down for the purposes of arguing probably at the end of the matter as to whether it forms part of the main case or it does not. And maybe I should say this, Mr. Oppenheimer, if you're going to want to have the evidence presented to form part of my consideration of the dispute, it seems to me that a formal application may need to be brought. And therefore, I would expect both yourself and your colleague to then formulate an approach as to how we should deal with it. And maybe at some stage, we would have to meet and discuss as to how we're going to deal with such an application. Having said that, unless there's anything from council, I would like to adjourn for lunch. Okay, we will adjourn. It's now 20 to 2. Can we be back by 20 to 3? The court shall adjourn.
examination.
Yes, Mr.
For the third time today, Mr. Roets, good afternoon.
Good afternoon.
Your Lordship, perhaps I should start with this before I get into my cross. We will in due course make submissions as to why a large part of the evidence that was read, factual, has no bearing in court. For that reason, I do not intend to spend considerable amount of time crossing that, because that will be the subject of our submissions in due course. So the point is, it should not be misconstrued as acceptance of the version given by Mr. Roets, and the decision I'm taking is solely on the basis of what is practical and what is relevant to the court. And just by way of illustration, it doesn't just limit to the question of fact. It also extends to some of the evidence that on the face of it appears like expert evidence, which nonetheless is still irrelevant. Particular reference I'm making is to the testimony that was led in respect of what genocide means, the dynamics thereto, because Mr. Ernst Roets' own version was that they're not relying on that. The same with the question of ethnic cleansing. He prefixed his discussion and his evidence in that respect with the concession that that's not what they're looking for. So I will not spend time dealing with the merits and demerits of those issues. That was just by way of illustration. Then perhaps if I could start with my cross-examination. Mr. Roets, as per your CV, which I will not refer to because I think it's common cause, in your expert summary, you note that you are a lawyer, correct?
That is correct.
And you have no other qualification, correct?
I do have some other qualifications, which I did a course in business management at the Gordon Institute for Business Science, and I did a master's degree in law, and I'm currently doing an LLD in law as well.
Yes, so I accept that you've got a qualification in law, the LLB and the LLM, and as I understand it, you're a candidate as well for the doctorate. Mm. The difficulty now I have is this introduction of a new qualification, because it puts me in a difficult question because I would not have prepared for that. And what is not permissible is for you to introduce new evidence under cross-examination. Because if you make reference to your summary report, which attaches your CV, the qualification you're now making reference to doesn't appear. Not so. I mean, I could, yeah. Is that where his CV is? Oh, sorry, in the blue bundle. Okay. Sorry, I should have taken you to, I thought it was just common cause. I should have taken you to the CV. So it appears as an annexure to your expert witness summary report. It appears on paginated, case lines pagination 138.
Here we go.
Page 138.
Yes.
Yes. Okay. So what appears there is your LLM. I presume that it was an error that the LLB is not there.
Yeah, it's not an error to my mind. If you have an LLM, I don't think it's necessary to also add that you have an LLB.
No, that's fair enough. And then the other qualification that appears is bullet point 3. Do you mind reading to us what that is?
Ernst is currently doing an LLD in public law at the University of Pretoria.
Sorry, the second bullet.
Program for Management Development at the Gordon Institute for Business Science, cum laude.
Yes. Would that not be a qualification different? So having regard to the ones you referred to, would it not be then that the one you're referring to now does not appear on your CV?
No, I'm not sure if I understand the question, because what I said to you is exactly what it says here in my CV.
Yes, which is what? Sorry.
Which is that I have an LLM,
Yes.
that I have a qualification at the Gordon Institute for Business Studies, and that I'm currently doing an LLD.
We'll come back to this point, Mr. Ernst Roets, because it's quite a nuanced point and it's an important one. Let's pause on that just for a second.
Sure.
We'll come back to it. But either than, let's accept these are your qualifications. Either than these, is there any other qualification you have?
You mean a tertiary qualification like a degree or a diploma?
Correct.
No.
Okay. So you would not have any qualification that speaks to qualitative and quantitative statistical data collection and analysis?
No, I don't have a degree in statistics, if that is what you ask.
Yes. Any qualification at all?
No. I've done some courses at university as part of my LLB, like criminology and so forth. But
yes.
But I'm not a statistician, if that's what you're getting at.
And you wouldn't be an expert in statistics either?
No, I would not describe myself as an expert, as a statistician, if that's the question.
Yes. Now, let's deal with your role in this matter. We've just established that you're an expert witness called by the complainant, not so?
Yes.
And I so happen to know Mr. Oppenheimer quite well, so I would imagine he would have taken you through the process of being an expert witness and what is expected of you, not so?
Yes.
And at a conceptual level, you can accept that an expert witness should provide independent opinion that is not partisan and does not seek to further the cause of either of the parties in the trial. Not so?
Yes, I would probably frame it differently. I think any expert any person who's an expert on a topic would, by definition, have a strong opinion. Opinion.
I'm going to read the question to you in the exact same terms I read the first time, and I'd expect a yes or no to it, and then I'll allow you to qualify.
Okay.
Because now I'm not too sure what the answer is.
Sure.
I'm saying at a conceptual level, as a matter of principle, an expert witness should provide independent opinion that is not partisan and does not seek to further the cause of either party in the trial. Yes or no?
So the way the question is phrased at a conceptual level, and that's right. I wonder if that means, is it a legal requirement? It's an ambiguous phrase. What it means to say at a conceptual level. Could be in a particular arena. Might be unfair to the witness to ask that question. Maybe it should be clarified. What is being asked?
So what informs the question is what I'd asked at first, that Mr. Oppenheimer would have taken you through what is expected of you, what qualities and traits you should possess as an expert witness. I'll substitute the word conceptual with principle. I'll say, bearing in mind your answer to this question I've just asked, referring to Mr. Oppenheimer, at a principle level, when you are an expert witness, you should have independence and no interest in the subject matter of the trial. Yes or no?
My lord, I find it difficult to answer either yes or no, because I think the answer is both yes or no, or it is neither. But if I have to answer, if I have to give a yes or no answer, I would say the answer is no.
Okay.
But I would have to qualify that.
Okay.
Just look at it. It seems like the problem is that there's a nested question. There's a question about, there's two questions from what I understand. The one is about the character traits that an expert ought to have. There's a second question, which is whether that expert must be independent from the interests of a party in the matter. And those are separate questions, and maybe for clarity, those questions should be asked separately, and separate answers can be given.
Yes, Mr. President.
I'll indulge my learned friend. At a principle level, Mr. Roets, can we accept that an expert witness must be independent in the trial in which they testify?
I'm not sure if I can say that the answer to that question is yes.
I'm not suggesting it should be a yes.
But I'm also not going if I'm forced to choose either yes or no, I will say no. That's what I said in my previous answer as well.
Okay. And again, at a principle level, you can't, as an expert witness, have an interest in the outcome of the trial. Is that correct?
I think that's incorrect.
Do you care to elaborate?
Sorry, I didn't get the answer.
I think it's incorrect. And the reason why I say it's incorrect is if you are an expert on a particular topic, you have a very strong opinion about what constitutes the facts with regard to that topic. You have a very strong opinion about the different arguments that play a role on that topic. And if there's a court case that, with regard to which this topic is relevant, you would have a strong opinion about what the appropriate outcome would be, given that you are an expert on the topic.
I accept that. The question is not about whether you should have an opinion or not, and to what degree you should hold that opinion. The question is, Mr. Roets, can you accept at a principle level that when you are called as an expert witness and you've just testified that you've been taken through what is required of an expert witness, can you accept at a principle level that as an expert witness, you cannot have an interest in the outcome of the trial? Yes or no?
Again, it's the same answer I've given earlier. I don't think it's a yes or no answer, but if you want me to force my answer to be either yes or no, then I will say no.
Okay.
This strikes me as a legal question in terms of who may testify as an expert. In other words, there will be case law around people who are experts in their own cases. So there are people who are mechanics, who are defendants, who are experts about the nature of a vehicle, and they have an interest in the outcome, and that they are both defendant and expert. And it sounds like what Mr. Roets is being asked is to provide an insight into what the legal position is regarding who is not an expert or what.
The position that he takes is not like a factual witness who will narrate this is what happened. And I think case law is also clear on that, what would be expected of an expert witness. So let's understand the questions are directed towards that.
Yes. Well, the question, in other words, it strikes me as a question that is answerable through case law, not through an answer the witness could give.
Yes.
In other words, there's a question as to what are the character traits a witness ought to have. Like, in other words, being able to fairly present the evidence in an honest manner. And then there's a separate question that's about a witness who has an interest in the outcome of the case. And this seems to be a matter for legal argument about the appropriateness of someone who has multiple roles in the matter. In other words, an example where someone's both defendant and expert.
No, but Mr. Oppenheimer, as I understand, you are right to say it ultimately becomes a point of law at the conclusion of the case. But I don't see why would counsel not cross-examine a witness to verify whether his or her understanding of the role that he plays. And therefore, it seems to me the question as to, do you appreciate that as an expert witness, this is expected of you. That witness can provide the court with an understanding where he or she's coming from in terms of the opinion that she's profiling for the court.
Yes, I think the difficulty is that there's an underlying assumption about what is legally required of an expert witness. That is not being put to the witness. And there's a vague question being asked about what would be nice to be a witness, as opposed to what do you see?
Well, let's put it this way, Mr. Oppenheimer. Isn't it that the witness can actually assist before you come to the question of the legal question? If the witness comes and testifies, and let's use an extreme example. The witness is told you must come and testify, and let's say this witness is a football player. For some reason, he's not properly taken through the system. He comes in thinking, yes, I'm coming to testify because I know this team played with that team. And suddenly he's asked questions that, or his evidence is led on the basis of technical aspects of soccer. Surely a question can be asked to this witness. What is your view about the stand you take in relation to this matter? And if he says, no, the view I take is that, let's use the local teams, Orlando Pirates and Kaizer Chiefs. And he says, the view I take is in favor of Kaizer Chiefs. That really answers the legal question. Is this an expert who is objective and non-partisan?
Yes, well, in other words, there's a particular legal question that arises in the circumstances where someone has multiple roles. In other words, an example I put to the court is a neutral case of a mechanic, for example, who is being sued for repairing a car badly and is the defendant in that matter, but then serves as their own expert to explain how the mechanics of the car work. That expert both has the obligation to be honest to the court about how the mechanics of the car work and has an interest in the matter because they serve two roles.
Yeah.
And so, in other words, there's an underlyingness to the question which implies that there could be something improper about holding two roles.
Yes.
That's not phrased in a legal sense, that's phrased in some other sense. And so, my concern is that the questions then are vague on that issue, and that it might be the kind of thing that could only really be resolved in legal argument. Mr. Roets could argue, could be asked questions about whether he has an interest in the outcome of the case. That could then be resolved in argument as to whether it has a role in his expertise.
But I thought that's the question which was asked. I recorded this here. Can an expert witness have an interest in the outcome? That's what I've typed out.
Yes, that's the ambiguity to my mind is this. It's one thing to ask the witness, do you have an interest in the outcome? The second version, which is the version I understand we put, is should a witness have an interest in the outcome? And that question is of a legal nature. The witness couldn't answer. The witness can answer whether he has an interest in the outcome. That is a legitimate direct question, and then he interface with the legal requirements.
Yes. Now, I hear your argument, Mr. Oppenheimer, but my view is that the question is permissible, and Mr. The question I think should be framed: do you have an interest in the outcome? That question can be asked to the witness.
As the court pleases. Mr. Roets, do you have an interest in the outcome of this trial?
Yes.
What form of interest do you have?
I've been working on the topic of farm attacks and farm murders, and through that I have also been working on the topic of hate speech for some time now.
Yes.
And I am convinced that farm murders, in my research on the topic of farm murders, through which I can confidently say that I regard myself an expert on the topic, I have come to the conclusion that the topic of hate speech is a very serious phenomenon. And in as far as I became focused on this topic because I want to do something about it. So yes, I do believe
Yes.
I want something to be done about the problem of farm murders and hate speech.
Yes. Then perhaps to just qualify my question, do you have a personal interest in the outcome of this trial? Either than as an expert, just personally, at a personal level.
Can you just define what you mean when you say personal?
Well, then let me perhaps continue with my cross-examination because it would have been a question that would come later. So then perhaps let's follow the sequence.
Sure.
Now, you are the head of policy, and it's the head of policy at AfriForum, which is the complainant. Is that not so?
Yes.
So you're employed there?
Yes, I'm an employee of AfriForum.
Yes. And you've just now also given evidence in support of the complainant's case, not so?
Yes.
Yes. Not only that, you are also the deponent to the affidavit of the complaint, not so?
Yes.
So to put it in short, you're playing three roles before this court. The first is that of an expert witness, and I'll make submissions about the independence of the expert witness. The second is you are here as the deponent to the affidavit that brought the complaint. And less relevant to the proceedings, but also relevant for purposes of the submissions I'm going to make in due course about your independence is that not only are you an employee of AfriForum, you also...
I said I would not describe what I'm advocating for as an ideology, but you can say an interest.
I'll accept that as your answer. I'm happy with it. In fact, you say in your book's preface, it's common cause now, which book I'm referring to, it's Kill the Boer, which you've led evidence in chief on.
Sure.
In chief on. And in that book, in the preface of that book, and I quote you, I can refer you to it. So if you do not mind me doing this, please stop me if I make reference to something and you actually want to see it first. Just for the sake of time, if you're happy.
It's no problem.
Okay. So in your preface, you say, my job includes the coordinating of our campaigns for the prioritizing of farmer tax in particular.
Correct.
You would have said that in your book.
Correct.
And when you say my job includes coordinating our, who's that reference to?
And it's in reference to AfriForum.
Yes. And also in your book, also under the section that deals with the preface to your book, you have a title or a topic called This is Personal, not so?
Yes.
And what comes underneath that topic, you list incidents where your own family and your own friends were victims of attack, not so?
Correct.
Let me now take you to the preface of your book still. It appears at Roman numeral X1X. Just give me a second. I need to gather my thoughts. I need to structure how I want to phrase this question properly, okay, if you don't mind. My apologies, Your Lordship. I'm just trying to structure the argument in my head, and I'm just making a judgment call as to whether I should go there first or not. Let me take him there, Your Lordship. It's the preface, and it's Roman numeral number 14, XIX. It's in fact the editor's notes. My apologies, Your Lordship.
May I ask just for clarification? In my book, the editor's note starts at X, V, I, so that's page 18. And I think what you said was page X, I, V, which is 14. I just want to make sure that I heard you correctly.
No, it's Roman numeral 14, XIX. Sorry, my apologies. XIX, yes, that's not 14.
19.
What is it?
19.
It's 19.
Yes.
Wow. Little one that struggled with Roman Dutch law now, isn't it? I want to make reference to the third line that appears there, the first sentence on the third line, where you say, is my lordship with me? Where you say, many of the source references are not necessary, but the author added them to neutralize the criticism that this book is sure to receive. Now, you correct me if I'm wrong. I understand you there to be saying you took good care in referencing the book. Would that be a fair assumption?
Yes.
Would it be equally fair to say that you would have taken due care in doing proper research before material is in your book? Is that? You testified yesterday about the graph that appears on page 198, not so?
Correct.
You took the court through the meaning of this graph, and I will venture to summarize what your evidence was. Your evidence, in essence, was this is a graph that depicts farm murders per week during the period of 1993, correct?
Correct.
And then you drew the court's attention to the bar that appears 1/3 into the graph, which has the number 1 on top of it, and the bar is red, correct?
Yes.
And you said that bar reflects the week just prior to the deceased Peter Mukaba sang the impugned song. Yes.
Yes.
And you drew a conclusion. Let me ask this first. Let me propose this first. You then suggested to the court that following the singing of that song, the weeks after, there was a spike in the number of farm murders. And the inference you drew from that is that the singing of the song must have led to that spike.
It could have led to that spike.
Yes. So your evidence is you in fact don't know.
My evidence is that there appears to be a trend where high-profile, highly publicized cases of hate speech tends to be followed by an increased number of farm attacks or farm murders.
So you don't know for a fact?
I don't know for a fact, no.
Okay.
I only know for a fact of individual cases where it was a direct result of hate speech.
Let me understand this. Your evidence before court is that you merely draw an inference of what caused the spike, and the inference is the singing of the song the week prior, correct?
Not necessarily. I'm not saying that my testimony was not and is not it was not and is not that the spike you can see on that graph is an immediate consequence of the singing of the song. I'm saying that it could be a consequence.
Because there are a number of variables that could have led to the spike.
Exactly.
And it could have been anything, literally anything.
Well, it could have
Within
been
reason.
many things, yes.
Yeah. Now, let's then go to the footnote of this table. And it's footnote 32. And it appears on page 372. Page 372 of your book. Perhaps before we deal with the material that I want to deal with, I want to put this proposition to you. The sum total of the complainant's case, as I understand it, is that there is a link between the singing of the impugned song and the farm murders and farm attacks. In general terms, I'm thereabout, am I not? In terms of what your case is.
No, that's not our case. That's not it.
Okay. Let me venture into trying and understand what your case is then. Your case is that certainly your version as an expert witness is that there is correlation in general terms between the political climate, the singing of the impugned song, and the attacks, the farm attacks.
My position is not, and I believe the way I explain it is not that there is a correlation, but that it seems that there is a correlation, or it seems that there might be. I cannot state it as a fact that this spike in farm murders was a direct result of Mr. Peter Mukaba singing the song. I'm saying after he sang the song, there was an increase. And it might be, him singing the song might be one of the reasons why there was this increase.
Yes. So your expert opinion then, if I understand you correctly, is that a number of things may cause farm murders and farm attacks, including the singing of the impugned song, not so?
Yes.
But to your knowledge, and you certainly did not testify, contrary to what I'm going to propose, there is no evidence of an instance where you can directly draw a correlation between the singing of the impugned song and any farm attack or murder. Is that so?
No, that's not so. No, I can point you to instances where you can clearly see that the song led to people being murdered.
Okay. Was that, just so I understand, I could have completely missed it yesterday. Was that part of your evidence yesterday?
Yes, it was.
Okay.
When we discussed chapter 14, I can point you to the relevant page if you want me to.
Sure, please.
Okay. It would be, I just need to find it. It might be the previous chapter. My lord, I'm going to need a minute to find on which page it is, but I can, if you want me to find it, I can. Otherwise, I can explain to you because I remember what I wrote. Would you prefer me to find the page for you?
For the sake of time.
I have found it. Here
Okay.
Page 194.
Okay, thank you.
The bottom of page 194 leading up to page 195.
Okay, yes.
So it's the story about the farmer Godfrey Hewer who was murdered.
Yes.
And a person named Ntutuko Chwene was convicted of having committed that murder.
Yes.
And then under testimony, he said that he was influenced by this particular song. And he said, the quote I read was, he explained that he had committed this murder because he had been influenced by the singing, the chanting of kill the Boer, kill the farmer. He then continued, I could have killed any other white man I came across at the time. My frustrations were directed to white men because they had what we did not have.
Yes. And perhaps let me just give you an opportunity as well. Would you perhaps have any other reference similar to this one?
Yes, although not similar references with regard to the same song. I can point you to similar references with regard to farm murders being committed or farm attacks being committed, where the attackers themselves have made it very clear that their motivations were political.
Yes, and that was part of evidence yesterday. Yes. Okay. Do you mind making reference to them as well?
Yes, it would be, let me see if I can find the page. Yeah, page 164 and 165 of the book.
Yes.
I list, it seems to me like 1, 2, 3, 4 examples. I list several examples.
Yes.
And they are each unique in their own way, but where it seems from the facts at hand quite clear that political motives was the primary drive behind these farm attacks.
No, the question was different, Mr. Roets. The question was, is there any evidence that you can refer to me, or to the court rather, where there's direct correlation between the singing of the impugned song and farm attacks and farm murders? That was the question.
No, the only example I have of this particular song,
yes,
that where there's very clear evidence in terms of someone testifying that I committed this murder because of this song,
yes,
I'm only aware of one such case.
Yes. Mm. Now, I'm putting a proposition to you that given the nature of the song, and in due course in oral submissions, I will make submissions to this court about what the song is, what it means for a particular sector of society, its historical import and importance. And I can accept that you're not privy to what my submissions will be. But as a matter of principle, you must accept that if there is any proposition, certainly by an expert witness, that a singing of a song which has such importance, at least for my clients, leads to farm murders, then that's a serious allegation, would you not accept?
Yes, it is very serious.
Yes. Now, let's go to page 372 of the book. And specifically footnote 32. Footnote 32 is the footnote that cross-references the graph we've just discussed.
Correct.
Do you know what that reference is under footnote 32?
Yes, it's a reference to a report that was published by AfriForum.
Yes. Mind explaining what the report was?
It's a report about the extent to which a link could be found between hate speech and farm murders.
Yes. Was it an independent report?
It was a report, well, the report was written by myself.
Yes.
During the course of writing this book and doing the research,
yes,
we decided that before publishing this book, this is such an important topic that we should publish an extract as a report.
So technically speaking, it's an extract of your book and not an independent report.
It's not entirely an extract because the report has more detail than the book about this particular topic. So the report looks at this issue in more detail than the book.
Well, Mr. Roets, I'm afraid what that report is actually an extract. You use the words, this is an extract of my book. Let me take you there. Do you mind giving us the case line reference? Your Lordship, the page I'm referring the court to is case lines paginated number 1789. And I'm afraid, let me apologize, Mr. Roets. The document I'm referring to, you don't have it in your position. It's under case lines. I'm just going to ask my attorney to show it to you.
Okay.
Your Lordship, the text I'm particularly referring to appears on page 6 of that document. Page 6 of the actual extract and not the pagination. Yes, yes.
Yes, got it.
So what you say there, Mr. Roets, is that this report is an edited extract from a book about farm matters due for publication in 2017, full stop. Now, there's a difference, and perhaps this is a discussion we should have. There's a difference, and this is why I asked the question whether it's independent or not. This is the point I was getting at. There's a difference between an independent report that is good for its own sake, and that is something different from an extract of a book. In other words, I can't purport something as an independent report if it's an extraction of something else. Would you accept that at a principle level?
Else and still be independent. But I'm not denying the fact that I wrote this report.
Yes. In other words, you relied as authority.
It was edited, so it has more detail. So I'm referring to the reader in a footnote to a report where if they want to read more about this particular point, they can go to that report.
Yes. But ultimately what we're dealing with is this. We can't lose sight of the fact that you call it an extract. Ultimately, with all the changes you're suggesting, ultimately at the core of this document is a piece of your book, is it not?
It's an edited piece of the book.
Correct. And I'm saying to you, you are then relying on a piece of that book as authority to that book. Not so.
I'm relying on my own research.
Yes.
The book is my own writing, and this report is my own writing.
My apologies for interjecting too.
Sure.
I didn't mean to. The point I'm simply making is this. You reference a document, presumably as authority, for the proposition you make, being the graph itself, correct?
No.
Okay. You reference the graph to this extract, do you not?
Yes.
And the intention is what?
The intention is to direct the reader to this report,
yes,
if they would like to read more about the at this section of the book.
Yes. And so does the report or the extract serve as an authority for the proposition, or rather serve as an authority for the graph you presented?
You can say yes, but I don't see it that way.
So it wasn't intended to be authority for it?
No, and the reason why it's not is because it's my own research. So I might just as well have added that graph to the book without a source reference because it's my research. It's not something that I'm taking from authority. In this particular case is myself, because I'm writing about research that I have done, and I'm doing that in the report, and I'm doing that in the book. And as far as I
understand that aspect.
Yeah.
You having produced the book as an author.
Yes.
You are an authority. But now I'm trying to understand the question which was posed. I'm not sure whether I followed. Whether the issue of authority relates to the book or relates to which one of the two are you raising as an issue? The book or the report?
Yes.
Well, my lord, thank you, my lordship. I was getting to precisely that point. The point is this, let me address you, Mr. Watts. I put the proposition to you earlier. In fact, it's your proposition that it's really important that you properly reference the book.
Yes.
Particularly as an expert, you'd appreciate the importance of independent sources, independent verifiable sources, as authorities to propositions you put in a book, correct?
Yes.
Yes. And I'm saying to you, you used your statistics, i.e., the report, as reference and authority to your book. Not so.
I think it's inaccurate. If you want to say I used it as authority, you can, but I think it's misleading because that's not the point of adding that footnote. It's common practice for an author to, in his source references, to reference other works that he himself has published.
No, sure.
And the reason, if an author does that, it's not because it's not to create some form of a false impression that he's citing independent research. It's to direct the reader who is interested in reading more about this topic to something that this author has written elsewhere about the same topic. So I don't think you can. The point of source references is usually to provide your authority, but you can also use a source reference just to direct the reader to something for further reading, especially if you are referencing yourself.
Yes.
My lord, just to be fair to the witness, reference is being made to the book and to the particular graph. Now, that graph is the report. It might be fair to point, in other words, this paper has been discovered moments ago. It might be fair to the witness to say, in your report, please turn to page 14 where the graph is present. Are there any underlying references in that graph? And we can find out if there is any underlying reference to how the graph is compiled, or whether it's a direction back to a source file. But to ask the witness without...
Just now, the issue here seems to be the question of authority. And it seems here you're dealing with authority in terms of academic world. Now, and then maybe that's what should be clarified to the witness. Are you saying if you have written a report, what is the authoritative value of your own work in relation to where you rely on a report that may have been produced by either other academics or other writers? It seems to me that's what clouds the whole question, because the witness says, I wrote the book, I wrote the report, and I referenced the report in the book. And maybe if I'm wrong, you can point me out because
Your Lordship, on the point of fairness to the witness that's been raised by my learned friend, in the beginning of my cross-examination of the witness, I specifically said to the witness, I will not take you through each and every page. If you accept and you are familiar with the content, you are within your right to, you can choose to direct me or ask of me to take you to the page. So in fairness, to me, I'd made that invitation to the witness already. And the witness did not suggest that he needs to be taken anywhere. Be that as it may, Your Lordship, the point is different. The point is not so much the authority. The point is simply this, and let me just put the proposition to Mr. Roets. When was the extract or the report compiled in relation to the book?
Yes, the report was published while I was writing the book, and it was published in 2016. And you will see in that sentence that you read earlier, it says that the book this is an edited extract from a book that is due to be published in 2017.
Yes.
But the book was eventually published in 2018.
Yes. So we've got an extract or a report from a book that is yet to be a book. Do I
Yes.
understand you correctly?
Yes, I think the word, it's not simply an extract. So what I did with writing the report, I took certain sections from the book as a baseline, and then I added to that, and I made it more comprehensive, and I turned it into a report. So it's not just an extract, it's more than an extract.
Very well. And just to be sure, the authority for the graph is your own research, is what you say.
Yes,
Yes.
that section of the book is my own research.
Yes, specifically the graph.
Yes, and in doing that research, I reference other sources, but the graph, the way it was drafted, was done by myself.
Yes. And the book itself makes no reference to what authorities you relied on, does it?
The authority?
The question I'm putting to the witness, Your Lordship, is that the book itself makes no reference to the authorities relied on to compile the graph.
That's specific to the graph, not
Specific to the
book
graph.
as a whole. Okay.
Indeed so, Your Lordship.
No, it does if you read the book in context. Because in chapter 3 of the book, I say there are several sources. Here are, I think I said there are 5 sources for the numbers with regard to farm murders. I say here are the different sources, and I discuss each one. So if in the book, when in the book, or where in the book I discuss the numbers with regard to farm murders, I believe it's quite evident that I use the sources that I mentioned in chapter 3, where I say these are the sources.
With respect, Mr. Rhodes, please. You're a double cum laude student. Surely that can't be right. If you're going to make a statement about statistics that have such a far-bearing consequence on this trial, I ask you for the authority of the graph. Your answer to that is, well, read the book in context, you'll figure out what I'm relying on specifically in relation to the graph. Surely that can't be it.
Well, there are 2 answers to that question. The one answer is that is indeed the point. That the sources, it's one of the first and the most significant points I mention in this book, is I say, here are the sources. At the beginning of the book, I say, here are the sources when we talk about the numbers for farm murders. The second part of the answer to your question is, below that graph, there's a reference to a report, of which I'm the author. In that report, there are, it seems to me, 133 source references. So that report is not just something I took out of the air. It's a researched, properly researched report.
Okay.
To be fair to the witness, these two documents that are being referred to by my learned friend be directed so the witness knows this page of your book, this page of the report. From what I can see from my looking at it, is an identical graph. And both should be put to the witness so the witness can answer the question as to where does the data come from. Which I understand is what my witness friend is asking. But it's not fair to do that without pointing the witness to those 2 different documents so the witness can look at it.
Mr. Kasiboto?
Your Lordship, I accept that that's probably what I'll do if ultimately that is what I was trying to get at. It's not what I'm trying to get at. I'm making reference to the same graph that is both in the report and in the book. I don't see the utility of contrasting them if ultimately we accept that they're cut and paste of the same thing. It's a practical difficulty.
The sources.
Yes.
That seemed to be your question. Your
Yes.
question, as I understand, Mr. Oppenheimer, the question is, you have these 2 documents, the book and the report. Now, let's accept that well, let's not even accept, the graph is there in the book. Question is, what's the, I think putting it much broader is, where did you find the authority to formulate the statistics that you used in your graph? I think that's really the essence of what the question is. And the witness has already said, from my own research, but I think the question now is, any other resource that you referenced your statistics?
Yes, in other words, the question is, if you turn to page 14 of the report, that graph is there, is there an underlying reference that goes anywhere beyond your own work or not?
Yes. I think so, Mr. Kasim. What do?
Your Lordship, let's do this, Your Lordship. I'm not interested in this exercise. I'm not going to undertake that exercise. What I will do is make one last parting point here. In any event, if I take the matter further, we're going into legal argument. What I will do is make one last proposal to the witness, and then I'll move from the question, and then we'll reserve it for argument.
Essence of what you're seeking from the witness. And wouldn't it help this court to understand if he says, I've got the graph, there are the statistics, there's 5 people, there's 4 people in this block, this is the number that happened after the singing of the song. Your question, as I understand, is, what's the source of those statistics as appearing on the graph?
I'm happy to do that then, Your Lordship. So the graph we've made reference to in your book appears in page 14 of the report. And is Your Lordship there?
Well, I must thank your attorney. And I want to say this, that I hope all attorneys and advocates start doing what she's doing. She just stands up and she opens my own page. And that's what Caseline does. And I sing this song because you can do it also. I think we need to encourage everybody to do it. It makes life it makes things very quick. Look, I was still trying to page. She stands up and I'm already connected there. Thank you very much.
So, Mr. Roets, the graph in question is in page 14. Are you there? Yes. And you say there, graph 2, farm murders per week during 1993. The week in which Peter Mukaba publicly started chanting, "Kill the Boer, kill the farmer," is indicated in orange. Can you please draw the court's attention to the source or the authority that led to the compilation of this graph?
Thank you for that. My Lord, I think I have discovered why there's an ambiguity on this issue.
Sorry, there's what?
Why there's this ambiguity about this issue, and I can be asked about that. And it's also an answer to the question that you asked. The graph on the book that we've been discussing on page 198 is a different way of visually indicating what is said on the table, in the table on the previous page. So there's a table on page 197 and then there's a graph on page 198. And they say essentially the same thing. Just the graph is just more visually explanatory. And there's a source reference to the table and there's a source reference to the graph. And I believe that the source reference I used to this table would be the same source reference as the one that's in the book, which is, I haven't found, I'm not there yet, but it would be the book Land of Sorrow, or the Afrikaans version thereof, which is Tertiary. I'm quite sure that that's the answer to the question.
If you perhaps know what page would you find that, Mr. Roets?
It looks like it's page 64 on the report, if that's what you're asking.
I don't have a page 64.
Apologies, footnote 64. Footnote 64 says, figures taken from Herman D. and Van Zyl C. 2013 Treergrond. And in the book, page 197, in other words, footnote 31, you turn to footnote 31 on page 372. It says figures taken from Herman D. Van Zyl C. and Nieuwoud I, compilers, 2013 Treergrond, die realiteit van plaasmoorde. So that's the source from which I took the figures that I used to compile that graph. If that is what the question is.
Yes. Now, the answer then is not the authority is you as a researcher. The answer is, for the statistics, what you've referred us to now.
The answer is both, because I used research that was published by someone else, and I applied my mind to that research, and I made a conclusion based on that research.
Mr. Roets, it's one of the two. You got the statistics from that source, or you did your research and got those statistics?
I did my research from that source, and then I drafted this report, or this table. This table is not
Yes.
in this book that I'm quoting.
Okay.
But the figures used to draft the table are from that book.
Yes. And I can tell you now, let me put the proposition to you. Footnote 64 does not reflect the stats in the graph. Nowhere in the reference in 64 do the statistics you refer to in the graph appear. That's a proposition I'm putting to you.
No,
is that true or not?
I don't think that's true.
Well, it is not true or it is. If it's your reference, then it must be true, surely.
It's true that that the numbers I used for that graph is taken from that source.
Yes, and I'm saying, I'm putting a proposition to you that that source does not give us the statistics you are relying on, or rather that are reflected in your graph.
Exactly, that's the point I'm making. I agree with you. Because I applied my mind to that source, and I drafted the graph.
Yes.
I drafted the graph that's in the book, but the graph isn't in the source that I'm using. I'm using the data from the source, and based on the data that I collected, extracted from that source, I drew a graph.
Okay. It's again going to be an issue for legal argument in terms of credibility specifically. Let me take you now to the preface of your book again.
Just on that question, my lord, refer to the witness. What might be fair to do is to read out what footnote 64 actually says. It says, figures taken from Herman D. and Van Zyl, Treergrond. Now, what the witness has said is that I used the figures, which were in the book, to produce a graph, which visually reflects the figures. So, what my learned friend has put to the witness is that you said something false because you were saying that the graph was not in the book. But his footnote does not say the graph is in the book, the underlying source reference to Treergrond. It says the figures are in the book, which reflect in his footnote. So there is no ambiguity whatsoever. But it's unfair to the witness to not point out what the footnote actually says, so that he can explain the difference between figures, graphs, a reference to the report, and underlying reference.
Your Lordship, unless you are interested in that exercise, the point I wanted to make was made, and I want to reserve it.
In argument.
Yes,
I think
and that's what I intend on doing.
I think we should proceed. Mr. Oppenheimer, if you think it's an important point, you can deal with it in your re-examination.
Now, let's still with the publisher of your book.
Mm-hmm.
So, who published the book, Mr. Roets?
The book was published by Kraal Uitgewers.
Do you know where they conduct their business?
Yes.
Where do they conduct their business?
At AfriForum's head office.
Which is the same business address as AfriForum?
That's correct.
Do you know what their relationship is with AfriForum?
Yes. AfriForum is a shareholder in the publishers.
And do you know what percentage it is?
I'm actually not sure. I can find out for you.
Okay.
I'm quite sure it's a majority shareholder.
Yes.
But if you want, I can get you the exact number.
Thank you. So, to understand your evidence, AfriForum is a certain percentage, let's say above 50, shareholder of the publisher.
Yes.
And they conduct business in the same building.
Yes, I don't want to testify on oath that it's 50%.
No, sure.
But it might be more than 50%.
No, sure.
You could say AfriForum is a significant shareholder.
Not only is it a majority shareholder, but it was actually the initiative of AfriForum, is it not?
No, it was an initiative. If I'm right, I believe it's was an initiative from Solidarity Trade Union, which is an affiliate of AfriForum, and then the publishers eventually moved from majority Solidarity ownership to majority AfriForum ownership. So management, you could say, or control of the company shifted from Solidarity to AfriForum.
I'm struggling to find the screenshot from the website of the publisher where it specifically says it's the initiative of AfriForum. What I will do, I mean, unless you want to take the point further, if I'm so required, I'll present it to you, or are you happy to concede that it might be the initiative of AfriForum?
Yes, we do use that term.
Okay.
That doesn't mean that AfriForum founded it. What that means is there are several institutions that are linked to AfriForum, and we describe these institutions as an initiative of AfriForum. But this is an interesting example because technically, Kroll Publishers was established somewhere else, and AfriForum took it over, and now we describe it as an initiative. But what that essentially means is that it is linked to AfriForum.
I'm putting to you that the publisher's website says AfriForum, or rather the publisher, is the initiative of AfriForum.
Yes.
Do you want to contest that?
No, I don't have any reason to doubt. The website says that.
Okay. And the executive head at the publisher is Miss Alana Bailey, isn't it?
Correct.
Not only is she the head at the publisher, but she's also the executive member of AfriForum, is she not?
That's correct.
Yes. Now, as a matter of principle, it is not too difficult for one. Let's start here. Typically what happens, and you'll advise me if you're not familiar, and that's where we'll leave it. Typically what would happen with the publication of the book is that the book will be sent to the proposed publisher, who then will get independent persons to review the book, make a decision as whether they want to sell the book or not, and if they do, then it's published by that publisher. Are you aware of that process?
Yes.
Okay. So what would have happened with your book is that you would have taken it to the publisher. Presumably, it was reviewed.
Yes. Yes.
And then the publisher published the book, and that's how it got onto the bookshelves.
Yes.
Let me now take you to the report that you testified on yesterday, which is the Special Committee of Inquiry into Farmer Tax, the 2003 report. Perhaps I should just give you my hard. No, I shouldn't give you my hard. It's in the file. Sorry. Your Lordship, what we've prepared is a bundle called the Respondents Discovered Documents. They are also on case lines. My attorney will assist you in navigating to the relevant pages. For your benefit, Mr. Roets, it's not paginated with case lines, so the reference is, oh, it is, 1292. Your Lordship, what should... Your Lordship, the report in question goes into hundreds of pages. So we've extracted the parts that I want to rely on for purposes of this cross-examination. And just for the sake of completeness, under page 1292 is the cover page to that report. So just to place on record, the document we're dealing with is a report of the Committee of Inquiry into Farmer Tax, dated 13 July 2003. I want to take you, Mr. Roets, to a specific page, which is page 1308. Under page 1308 is the heading composition of the committee. Are you there?
Yes.
Okay. And then the sentence following the first paragraph is a sentence that says the members of the committee are as follows. Mm-hmm. And for the point that I want to make, please bear with me, I'll actually read out the members of the committee because it's integral to the point I want to make.
Sorry, Mr. I just need to play with two screens because I battle switching off and on. Just give me 1 second. Yes, you may proceed there. You're on page
1308, Your Lordship.
1308.
Now, it says the members of the committee are as follows. Advocate C.F. Du Plessis, Senior Counsel, Chairperson, who's a retired Director of Public Prosecutions in the Northern Cape. He has wide experience in criminal law, including the prosecutions of cases resulting from farm attacks. 2, Ms. M.E.A. De Haas, a senior lecturer at the School of Anthropology and Psychology at the University of Natal. She has done extensive research on inter alia violence in KwaZulu-Natal. 3, Ms. J. Dlamini, also a senior researcher at the Institute for Human Rights and Criminal Studies at Technikon South Africa, and co-author with Ms. Mystery of the report mentioned above. 4, Ms. D. Mystery, a senior researcher at the Institute for Human Rights and Criminal Studies at Technikon South Africa. She is a co-author of a research report on perpetrators of farm attacks. 5, Professor C.J. Moorman, head of the Department of Criminology at the University of the North. He has published research papers on the phenomenon of farm attacks. 6, Mr. M. rassespanning, Secretary for Safety and Security, who served as the representative of SAPS on the committee. 6. My apologies, Your Lordship. Mr. M. rassespanning. Next, Advocate M. Schoenstaich, senior researcher at the Institute for Security Studies. He specializes in criminal prevention and policing and is co-author of a research report on attacks on farms. Last one, Ms. H.C. It is a list of illustrious people that meant that committee, wouldn't you say?
Yes.
And then when you flip the page to 1309, under the paragraph terms of reference of the committee, it says the terms of reference of the committee were as follows: to inquire into the ongoing spate of attacks on farms, which include violent criminal acts such as murder, robbery, rape, etc., to determine the motives and factors behind these attacks, and to make recommendations on their findings. The inquiry should also include the following: review of court cases, interviews with sentenced persons, interviews with family victims, interviews with investigating officers, and interviews with any other person or institution which the committee may deem necessary for the purposes of the report. On your opinion as an expert on the subject matter, is there any group of persons that you feel ought to have been concluded in these terms of reference?
Ought to have what?
Ought to have been included in the list of these terms of reference.
No, I think there might be, if I think about it for some time, but I can't think of any.
Yes.
This seems to me to be quite comprehensive.
Yes, that's my view as well, and that would have been my proposition to you. Now, let's then turn to page 1339. Just to orientate the court and for the benefit of the public, what we have in front of us under page 1339 is a table which forms part of the report, and it deals with various years. The intention of the table is to report on the apparent motive for farm attacks for the period 1998 to 2001. What then appears at the first row after the heading is the year in question. Next to that row is a heading robbery, under which numbers are reflected to reflect the number of robberies committed in that year. In other words, the conclusion on the table is that, using the data I've just given as an example, 552 people would have been victims of farm attacks because of the motive of robbery. As
Yes.
I understand it, that's what it seeks to depict.
The emphasis here is on what the apparent motive was.
Yes.
Not what the crime was, but what the motive for the crime was. That's correct.
Precisely.
Yes.
Precisely. And then what I'm interested in is right at the bottom, which are the totals, the sums, the percentage sums. You will see there, right at the bottom, the report concludes that for the period in question, of the farm attacks for the relevant period, 89.3% of them were motivated by robbery.
Yes.
And if you move 2 rows to the right, you have a reflection of, at least as far as the report is concerned, that only 2% of farm murders were motivated by racial or political motive. Do you see that?
Yes.
Now, let me put a proposition to you. I mean, of course, you would not have compiled this table, and you nonetheless gave evidence on it briefly yesterday. The table itself does not reflect, or anywhere in that report for that matter, reflect as accepting the 2% as the correct percentage. It does not reflect of that percentage how many. In other words, it does not give a breakdown of the races of the 2%. I'm putting that as a proposition to you.
Yes.
Yes. Nor does it give an indication of what specifically were the racial or political motives. So in other words, it doesn't say of this 2%, 0.5% was caused by racial motives following the singing of a song, for example. It simply says it's racially influenced.
Yes.
It could well be that it would have been a white person killing a black person, for example. That falls within that 2%.
In theory, yes.
Yes.
Practice, no.
It could have been anything. The point is there are many variables that are not reflected in this table.
Yes.
Yes. In fact, and I'll take you to the pages if you want, but ultimately you say in your book, the link between farm murders and the motive is a controversial issue because of lack of information in that regard.
Yes, it is controversial, but for more than the mere fact that there's a lack of information.
Yes.
Partly because of a lack of information.
Just then, as a general proposition, it's really difficult to pin down motives that lead to farm attacks and farm murders.
Correct.
Yes.
I, however, don't think it's impossible. I think the appropriate research has not been done.
But as it stands, there is no evidence that you find credible that specifically links farm attacks and farm murders to specific political motives.
No, there is evidence to that effect.
No. What I'm saying to you, Mr. Roets, is this. There is no evidence, and I think this is what I thought that's what we agreed on. I am saying there is no evidence that suggests, or any credible evidence. In fact, let me just read to you what I just said. I had said to you, in your book, you say that the link between farm murders and farm attacks and the motive behind those attacks is a controversial subject because there's no sufficient data in that respect.
Yes, there is
amongst
data.
Other things.
Yes.
Yes.
Yes. I'm not saying that there's no data. I'm saying there's insufficient. We can make better conclusions if we have more data.
Yes. And you are aware that the report itself, just going back to the book now, to the report I've referred to, sorry, at page 49, the difficulty, Your Lordship, is that the report itself does not have its own numbering, but it appears as page 49 to the report itself, and it appears as paginated number
1339.
Yes. I'm told it's page 1340, Your Lordship. The report itself at page 49 says, there seems to be a perception that it happens frequently that a farmer or his family are attacked, but nothing is taken. That is often seen as proof that the motive for farm attacks is not robbery, but something more sinister. Often these cases receive much publicity, reinforcing the belief that it is a common phenomenon. The committee's investigations show, however, that there are relatively few farm attacks where nothing is robbed, without there being a logical explanation for it. It goes on. The belief that nothing has been taken in a particular farm attack is often based on suppositions and incorrect information. A case in point is the Strippers case, which received much publicity at the time and which was referred to the committee by the Transvaal Agricultural Union for special investigation. Harold and Nelly Shippers were brutally murdered on their farm in the Ermelo district on 2 December 1997. The TAU was under the impression that nothing had been stolen, whereas in fact, cupboards in the house had been emptied and the safe opened and several handguns and other weapons taken. The attackers had also stolen Mrs. Shipper's motor car, which had in fact led to their being traced by the police. Do you accept that as being reflected in the report?
You mean, do I accept that what you've just read is in fact in the report?
Yes.
Yes. Yes.
Do you have any comment on it?
Yes, I think they are right, but I think that what they describe in what the authors of this report describes as a belief, I'm not sure if they use a widespread belief or widely held belief, is in fact not a widely held belief. It's not a widely held belief that usually nothing is stolen. It is a widely held belief, and it is my opinion as well, that oftentimes you find that that which is stolen is completely disproportionate, or let's put it differently, that the levels of violence inflicted on the victims is completely disproportionate to the value of the items that have been stolen.
Okay. Your Lordship, I was actually about to address you on that because my attorney has just indicated what time it is. I just want to put one last question to the witness, then perhaps we can adjourn and resume tomorrow.
Okay.
You testified yesterday, and this is going to be part of my, seems to be quite a lot of, at least in my view, problems with the referencing and the research of the book. And let me not go there yet. One example of this is the comment you made yesterday, the extract you read from the book. For interest of time, I'm not going to refer to it unless you ask me to, where you say you had taken text from the Facebook page of Mr. Malema, not so?
Yes.
He's going to come here and tell this court that he's never had Facebook before. And he doesn't have it to date. And your testimony to this court is that you do proper research on your work and you stand by it. What is your response to what his evidence will be, which is that he doesn't have Facebook?
Well, I did not leave out, I did not exclude that possibility in the way in which I approached that issue in the book.
Then perhaps let's go there.
Well, just for my benefit, this is just page numbers you be referenced so that I can see which footnote, which page.
My attorney advises me it's on page 208 of the book. 208, Your Lordship. Let's start at the second paragraph of that page. There you say, meanwhile, a Malema supporter started publishing updates about farm attacks on Malema's Facebook page every few hours. The page had almost 12,000 followers at the time. One of the posts stated, 3,000 farmers dead since '94. We lost more people than that. We are far from being even. So kill the boer, kill the farmer. In another post, the same Malema supporter wrote that 8 farmers had been murdered on farms in Limpopo since the beginning of February 2010. When asked about his intentions behind the post, he responded that he had never killed anyone, but that he did not have any sympathy for farmers who were murdered. Quote, "Sue me for not shedding a tear," close quote. Another Malema supporter posted on his public page, and I will not read the extract. Now, it is clear what the intention of all of this is. And I'm putting it to you that Mr. Malema never has, nor does he have Facebook. Do you have a response to that?
Yes, my response is that I remember that. I remember this, witnessing it back then, and I remember writing this. There was a Facebook page which was called Julius Malema, and it had a picture of Julius Malema, and it had 12,000 followers. And the point of this section is not to say that this is what Mr. Malema is saying. The point of this section is to say this is what people who identify as supporters of Mr. Malema are saying. So that's why the emphasis here is on the fact that Malema supporters are saying the following thing. It might be true that the Facebook page in question was not administrated by Mr. Malema. The point, however, is that...
Sorry, hold on, Mr. Roth, sorry. The question is clear here. Do you accept that Mr. Malema has no Facebook page, neither has he ever had one?
I can't accept that because I don't have sufficient evidence if that's true or false. If he says that, then maybe that's the case.
Okay, so it's possible that he doesn't have
yes.
it. So to then positively affirm that Mr. Malema supports...
No, sorry, there's an objection.
Oh, sorry.
The technical thing about Facebook works, the term Facebook page is ambiguous in the sense that one can have a Facebook profile, which is for a person. So I have a profile that is me. And then there's a page.
Your Lordship, I'm so sorry, my learned friend. I just need to understand whether he's leading evidence or he's making a point about the cross-exam.
No, I want, in other words, the question to be, I want to say that there is an ambiguity about what a page is and a profile is.
But it seems, Mr. Oppenheimer, the witness seems to understand the question quite well. And if his answer maybe needs to be clarified, you could do that in a reply.
Well, I want to know what is being put
forward. Oh, okay.
Mr. Malema's, what's being said is that Mr. Malema will testify that he does not have a Facebook page. And that's an ambiguous term because it should refer to one of two things. One is a personal profile on Facebook, and the other one is a page, which is more like a business site can have a page, for example, and that can be set up. And it might be that, I just want to know what it is that's being put to the witness. Is it the page or the profile?
Yes.
Your Lordship, can I please refer the court to page 373 of the book, which is a reference to what I've just read out. It's a footnote 40. It says there's reference to the text I've just read. Screenshot Julius Malema in March 2010. Now, the proposition I'm simply making, and perhaps I don't need to take the point any further, the point I'm simply making is there's a firm, 3 times, just on these 2 pages, firm reference to the fact that this is a Facebook page that belongs to Mr. Malema. I'm putting it to Mr. Roets that he's never had one. It doesn't seem to contest that evidence, and therefore we should take it no further, my lord. And if this is an opportune time, then perhaps we could adjourn.
Well, would it not be fair to also put what, the clarity purposes, put what Mr. Oppenheimer has said, the distinction between having a profile or your profile appearing and having the page itself to the witness so that the witness can clarify whether he understands it or not.
Your Lordship, there is no difference between a profile and a page. And taking cue from my learned friend, I'm going to lead evidence before this court. What typically happens with social media, you get onto Twitter, for example, or Facebook, you can only have one thing, which is a profile or a page. It's semantics. Ultimately, the owner of the page or the profile has control of what goes on it and what doesn't go on it. The suggestion from the book is that Mr. Malema owns such a page or profile. Technically speaking, there's no difference between the two. What you do have are accounts that are in support of Mr. Malema, for example. You've got support groups of Mr. Malema, for example. They are either pages or profiles, semantics. Ultimately, the question is, does Mr. Malema have a profile or a page? And the answer is no. And that is what the book was insinuating, and it is not so.
Okay. Thank you. As I said, it can be dealt with in evidence in reply, and also probably we could deal with it at the end when the case has been argued. Thank you very much. We will, at this stage, then adjourn. Mr. Roets, you're still going to be under oath. We will continue tomorrow at 10 o'clock with the court rise.
I just need to remember this.